G. Analysis. Section 1. What courses of action are available to the governor in exercise of his powers under Article 200 of the Constitution? Para 169. A plain reading of Article 200 of the Constitution indicates that when a bill is passed by the legislature of a state, it is mandatorily required to be placed before the governor for his assent. This is because without receiving the assent of the president, a bill cannot become an act. However, when a bill is presented to the governor for his assent, the governor is required to make a declaration from the three options available to him under the substantive part of Article 200, that is, to assent, to withhold assent, or to reserve the bill for the consideration of the president. Para 170. The first proviso prescribes a mechanism whereby the governor may return a bill which is not a money bill back to the state legislature, requesting them to reconsider the bill or certain provisions thereof, or consider the possibility of making certain amendments to it. Once a bill is so returned by the governor, the state legislature is required to take note of the suggestions made by the governor and reconsider the bill accordingly. If the bill, after such reconsideration by the state legislature, is again passed and presented to the governor, then in such circumstances, as per the first proviso, the governor would then be prohibited from withholding his assent to the bill. Para 171. The second proviso provides for a specific situation wherein the governor is mandated to reserve a bill for the consideration of the president if, in his opinion, the bill upon becoming law would so derogate from the powers of the High Court as to endanger the position within the High Court has been designed to fill by the Constitution. Para 172. One of the principal contentions advanced by the learned Attorney General before us was that the first proviso to Article 200 provides an independent fourth course of action to the governor besides the three other options available to him under the substantive part of the article. To put it differently, his argument was that the governor may either withhold assent to a bill simpliciter as provided under the substantive part of Article 200, or he may invoke the procedure prescribed under the first proviso and return the bill back to the state legislature along with such a message as is mentioned in the first proviso. In other words, he contended that where the governor declares a simpliciter withholding of assent, the same would be an absolute veto of the bill, and the state legislature would have no occasion to reconsider the bill in such a scenario. As a corollary, the first proviso would have no applicability, and the state legislature would not be entitled to reconsider the bill on its own motion. Para 173. He argued that in cases where the bill suffers from some gross and manifest unconstitutionality, the governor need not invoke the procedure mentioned in the first proviso, and it would be sufficient if he declares a simpliciter withholding of the bill. As a corollary, he submitted that the procedure prescribed under the first proviso sorry, Para 173. He argued that in cases where the bill suffers from some gross and manifest unconstitutionality, the governor need not invoke the procedure mentioned in the first proviso, and it would be sufficient if he declares a simpliciter withholding of the bill. As a corollary, he submitted that the procedure prescribed under the first proviso may be followed by the governor when he is of the belief that the bill, which is otherwise constitutional, may benefit from certain amendments, and in such a case, he may send a message to the state legislature suggesting certain amendments to the bill. Para 174. In other words, his contention was that simpliciter withholding is to be opted for the governor in his position as a custodian of the constitution in the state, while the procedure prescribed in the first proviso is to be followed by him in his role as a friend, philosopher, and guide of the state government, with a view to improve an otherwise constitutionally innocuous piece of legislation. The aforesaid contention, para 175. The aforesaid contention of the Attorney General was met by the petitioner by placing reliance on the recent decision of this court in state of Punjab, quoted supra, wherein it was held that the option of withholding of assent under the substantive part of Article 200 is attached with the first proviso. The petitioner contended that in light of the said observation, it is not open for the governor to undertake any simpliciter withholding of a bill presented to him, and he must mandatorily resort to the procedure indicated in the first proviso if he decides to withhold assent to a bill. Para 176. The Attorney General, on the other hand, raised doubts as regards the correctness of the decision in state of Punjab, wide supra, and argued that the said decision was rendered without having regard to the earlier decisions given by larger benches of this court. In particular, he placed reliance on certain observations made by the Constitution bench in Valluri Basavaya Chowdhury, White Supra, to support his contention. Para 177. In response, the petitioner argued in favor of the decision in state of Punjab, quoted supra, and submitted that the observations made in Valluri Basavaya Chowdhury, quoted supra, were made in a case where this court was not dealing with the interpretation of Article 200 of the Constitution. Thus, the observations made therein as regards Article 200 could be said to be obiter dicta at best. Mr. Dwivedi went to the extent of submitting that the observations of this court being relied upon by the Attorney General cannot be construed as obiter dicta, as they were mere passing remarks irrelevant to the lists before the court in that case. Para 178. It is in this backdrop that we are called upon to ascertain whether the observations made in Valluri Basavaya Chowdhury, quoted supra, can be reconciled with the decision of this court in state of Punjab, quoted supra. The consequence of this inquiry would be that it would determine whether the constitutional scheme of Article 200 envisages a simpliciter withholding of assent by the governor. In other words, if the decision in state of Punjab, quoted supra, is found to be per incurium, it would mean that the governor under Article 200 has the power of exercising an absolute veto upon any bill which is presented to him for assent. Para 179. Before going into the question of whether the observations made in Valluri Basavaya Chowdhury, quoted supra, could be said to be the ratio, obiter, or irrelevant to the list, we deem it necessary to reproduce the observations relied upon by the Attorney General in support of his submission. Quote, Para 19. The governor is, however, made a component part of the legislature of a state under Article 168, because every bill passed by the state legislature has to be reserved for the assent under Article 200. Under that article, the governor can adopt one of the three courses. Namely, he may give his assent to it, in which case the bill becomes a law, or item 2, emphasis supplied, he may, except in the case of a money bill, withhold his assent therefrom, in which the case the bill falls through unless the procedure indicated in the first proviso is followed. That is, return the bill to the assembly for reconsideration with a message, Or item 3, he may, subject to ministerial advice, reserve the bill for the consideration of the president, in which case the president will adopt the procedure laid down in Article 201. The first proviso to Article 200 deals with a situation where the governor is bound to give his assent when the bill is reconsidered and passed by the assembly. The second proviso to that article makes the reservation for consideration of the president obligatory, where the bill would, if it becomes law, derogate from the powers of the High Court. Thus, it is clear that a bill passed by a state assembly may become law if the governor gives his assent to it, or if, having been reserved by the governor for the consideration of the president, it is assented to by the president. The governor is therefore one of the three components of a state legislature. The only other legislative function of the governor is that of promulgating ordinances under Article 213, Clause 1, when both the houses of the state legislature or the legislative assembly, where the legislature is unicameral, are not in session. The the ordinance making power of the governor is similar to that of the president, and it is coextensive with the legislative powers of the state legislature. End of quote. Emphasis supplied. Para 180. The crux of the controversy as regards whether the first proviso provides an independent course of action to the governor lies in the use of the expression, in which case the bill falls through unless the procedure indicated in the first proviso is followed. End of quote. However, what is interesting to note is that this expression did not come to be used for the first time in Valluri Basavaya Chowdhury quoted Supra. Much prior to the said decision, Justice S.R. Das, as his lordship then was, in a concurring upon an opinion in state of Bihar versus Maharaja Diraja Sir Kameshwar Singh of Darbhanga, reported in 1952, 1 SCC 528, observed as follows. Quote, Para 235. The procedure to be followed after a bill is passed by the State Assembly is laid down in Article 200. Under that article, the governor can do one of three things, namely, he may declare that he assents to it, in which case the bill becomes a law, or he may declare that he withholds assent therefrom, in which case the bill falls through, unless the procedure indicated in the proviso is followed, or he may declare that he reserves the bill for the consideration of the president, in which case the president will adopt the procedure laid down in Article 201. Under that article, the president shall declare either that he assents to the bill, in which case the bill will become law, or that he withholds assent therefrom, in which case the bill falls through unless the procedure indicated in the proviso is followed. Thus, it is clear that a bill passed by a state assembly may become a law if the governor gives his assent to it, or if, having been reserved by the governor for the consideration of the president, it is assented to by the president. In the latter event happening, the argument of the learned counsel for the petitioners will require that what has become a law by the assent of the president will, in order to be effective, have to be again reserved for the consideration of the president. A curious conclusion I should be loath to reach unless I am compelled to do so. Article 200 does not contemplate a second reservation by the governor. End of quote. Emphasis supplied. Para 181. The same expression also came to be used by a three-judge bench in Hixt quoted Supra, wherein it was observed thus. Quote, Para 85. The constitutional position of a governor is clearly defined. The governor is made a component part of the legislature of a state under Article 168, because every bill passed by the state legislature has to be reserved for the assent of the governor under Article 200. Under that article, the governor can adopt one of the three courses, namely, number one, he may give his assent to it, in which case the bill becomes a law, or number two, emphasis begins, he may, except in the case of a money bill, withhold his assent therefrom, in which case the bill falls through unless the procedure indicated in the first proviso is followed. That is, return the bill to the assembly for consideration with a message, end of emphasis, or number three, He may, on the advice of the Council of Ministers, reserve the bill for the consideration of the President, in which case the President will adopt the procedure laid down in Article 201. The first proviso to Article 200 deals with a situation where the Governor is bound to give his assent and the bill is reconsidered and passed by the Assembly. End of quote. Emphasis supplied. Para 182. In this court in state of Punjab quoted Supra, wherein one of us, J.B. Pardiwala, Justice, was part of the bench, observed that the second proviso to Article 200 is in the form of an exception as it restricts the choice that the governor otherwise has under the substantive part of Article 200. It observed that the use of the expression shall not assent to but shall reserve for the consideration of the President makes it abundantly clear that the Governor has no choice but to reserve a bill for the consideration of the President if the bill is of the description given in the second proviso. This court further held that, unlike the second proviso, which is in the form of an exception, the first proviso is in the form of an explanation, and the same is made clear from the use of the expression may in the first proviso. The court observed that the expression may has been used because the first proviso attaches with the option of withholding of assent, and it is a matter of choice for the governor if he wants to withhold assent to a bill or if he wishes to exercise the other two options available to him, namely declaring assent or reserving the bill for the consideration of the President. Taking note of the expression shall not withhold assent therefrom used in the first proviso, the court observed that the expression signified that the first proviso was attached to the option of withholding of assent alone. In lieu of this, the court held that upon withholding of assent to a bill, the governor is mandatorily required to follow the procedure prescribed in the first proviso. The relevant observations are reproduced herein below. Quote, Para 20. The present case turns upon how the first proviso is to be construed. In construing the first proviso, it needs to be noted that the substantive part of Article 200 provides the governor with three options: an option to assent, an option to withhold assent, and an option to reserve the bill for the consideration of the President. Beginning of emphasis. The first proviso opens with the expression the governor may, in contrast to the second proviso, which begins with the expression the governor shall not assent. The may in the first proviso is because the first proviso follows the substantive part which contains three options for the governor. The first proviso does not qualify the first option where the governor assents to the bill, nor the third option reserving the bill for consideration of the President. The first proviso attaches to the second option, that is withholding of assent, and hence begins with an enabling expression may. By the mandate of the second proviso, there is an embargo on the governor assenting to a bill which derogates from the powers of the High Court under the Constitution. The governor is, by the mandate of the Constitution, required to reserve such a bill for consideration of the President. Para 21. The second proviso impacts upon the option which is provided by the substantive part of Article 200 to the governor to reserve a bill for the consideration of the President by making it mandatory in the situation envisaged there. The option of reserving a bill for the consideration of the President is turned into a mandate where the governor has no option but to reserve it for the consideration of the President. Emphasis beginning. The second proviso is therefore in the nature of an exception to the option which is granted to the governor by the substantive part of Article 200 to reserve any bill for the consideration of the President. Para 22. Emphasis. A proviso, as is well settled, may fulfill the purpose of being an exception. Sometimes, however, a proviso may be in the form of an explanation or in addition to the substantive provision of a statute. The first proviso allows the governor, where the bill is not a money bill, to send it back to the legislature together with a message. End of emphasis. In terms of the message, the legislature may be requested by the governor to reconsider the entirety of the bill. This may happen, for instance, where the governor believes that the entirety of the bill suffers from an infirmity. Alternatively, the governor may request the legislature to reconsider any specific provision of the bill. While returning the bill, the governor may express the desirability of introducing an amendment in the bill. The desirability of an amendment may arise with a view to cure an infirmity or deficiency in the bill. Emphasis. The concluding part of the first proviso, however, stipulates that if the bill is passed again by the legislature, either with or without amendments, the governor shall not withhold assent therefrom upon presentation. The concluding phrase, shall not withhold assent therefrom, is a clear indicator that the exercise of the power under the first proviso is relatable to the withholding of the assent by the governor to the bill in the first instance. That is why, in the concluding part, the first proviso indicates that upon the passing of the bill by the legislature, either with or without amendments, the governor shall not withhold assent. The role which is ascribed by the first proviso to the governor is recommendatory in nature and it does not bind the state legislature. Para 23 emphasis. This is compatible with the fundamental tenet of a parliamentary form of government where the power to enact legislation is entrusted to the elected representatives of the people. The governor, as a guiding statesman, may recommend reconsideration of the entirety of the bill or any part thereof and even indicate the desirability of introducing amendments. However, the ultimate decision on whether or not to accept the advice of the governor as contained in the message belongs to the legislature alone. That the message of the governor does not bind the legislature is evident from the use of the expression if the bill is passed again with or without amendments. Para 24 emphasis. The substantive part of Article 200 empowers the governor to withhold assent to the bill. In such an event, the governor must mandatorily follow the course of action which is indicated in the first proviso of communicating to the state legislature as soon as possible a message warranting the reconsideration of the bill. The expression as soon as possible is significant. It conveys a constitutional imperative of expedition. Failure to take a call and keeping a bill duly passed for indeterminate periods is a course of action inconsistent with that expression. Constitutional language is not surplusage. End of emphasis. In state of Telangana versus Governor of Telangana, otherwise State of Telangana versus Governor of Telangana 2024 1 SCC 405, this court observed that, quote, the expression as soon as possible has significant constitutional content and must be borne in mind by constitutional authorities. Emphasis. The Constitution evidently contains this provision, bearing in mind the importance which has been attached to the power of legislation which squarely lies in the domain of the state legislature. The governor cannot be at liberty to keep the bill pending indefinitely without any action whatsoever. Para 25. Emphasis. The governor, as an unelected head of the state, is entrusted with certain constitutional powers. However, this power cannot be used to thwart the normal course of lawmaking by the state legislatures. Consequently, if the governor decides to withhold assent under the substantive part of Article 200, the logical course of action is to pursue the course indicated in the first proviso of remitting the bill to the state legislature for reconsideration. In other words, the power to withhold assent under the substantive part of Article 200 must be read together with the consequential course of action to be adopted by the governor under the first proviso. If the first proviso is not read in juxtaposition to the power to withhold assent conferred by the substantive part of Article 200, the governor, as the unelected head of state, would be in a position to virtually veto the functioning of the legislative domain by a duly elected legislature by simply declaring that assent is withheld without any further recourse. Such a course of action would be contrary to fundamental principles of a constitutional democracy based on a parliamentary pattern of governance. Therefore, when the governor decides to withhold assent under the substantive part of Article 200, the course of action which is to be followed is that which is indicated in the first proviso. The governor is under Article 168 a part of the legislature and is bound by the constitutional regime. End of emphasis. Para 26. Insofar as money bills are concerned, the power of the governor to return a bill in terms of the first proviso is excluded from the purview of the constitutional power of the governor. Money bills are governed by Article 207, in terms of which the recommendation of the governor is required for the introduction of the bill on a matter specified in subclauses A to F of clause 1 of Article 199. End of quote. Emphasis applied. Para 183. Placing reliance on the expression unless the procedure indicated in the first proviso is followed, the learned Attorney General submitted that the decision as regards whether the procedure prescribed under the first proviso is to be invoked or not is the discretion of the governor. It is only when governor decides to return the withheld bill along with a message that the first proviso would come into play. In other words, if the governor believes that the bill is constitutionally infirm and beyond any remedial changes, then he may choose not to return the bill along with a message and may simply declare that he is withholding assent to the bill, in which case the bill would fall through or lapse. Para 184. Although the argument is seemingly lucrative and appealing, and the petitioner also could not provide a concrete reply to the same during the course of the arguments and instead took shelter under the semantics of obiter dicta and ratio decidendi, yet we deem it necessary to explain how the argument is short-sighted, half-baked, and suffers from an inherent fallacy. Para 185. As the observation made by this court in the three decisions referred to above holds that the bill would fall through unless the procedure prescribed in the first proviso is followed, we first need to understand the procedure that is prescribed in the first proviso. The proviso stipulates that when any bill other than a money bill is presented to the governor for assent, he may, as soon as possible, return it to the state legislature together with a message. As regards the content of the message, the proviso stipulates that the governor may request the house or houses of the state legislature to reconsider the bill or certain parts of it and also explore the desirability of introducing certain amendments as may be suggested by the governor in the message. Once the bill is so returned together with the message, the House or Houses are required to reconsider the bill in accordance with the recommendations contained in the message of the governor. If the bill is then passed again by the House or Houses with or without amendments and presented to the governor, then the governor cannot withhold assent from such a bill. Para 186. A close reading of the first proviso reveals that the action of returning the bill to the state legislature by the governor is qualified by the expression as soon as possible. However, once the bill has been returned to the state legislature by the governor, there is no such expediency required on part of the state legislature in reconsidering the bill. Further, once the bill is reconsidered and passed again by the state legislature, there is again a mandate on the governor not to withhold assent to such a bill. The only obligation upon the state legislature is to mandatorily take into consideration the suggestions contained in the message sent by the governor along with the bill. However, the state legislature is not under an obligation to mandatorily introduce any amendments suggested by the governor, and it may proceed to repass the bill without any amendments. Para 187. Since there is no obligation on the state legislature to repass the bill returned by the governor under the first proviso, the expression falls through can only refer to those situations where the state legislature elects not to pass the bill for reconsideration again, and in such circumstances causing the bill to lapse. There is nothing in the first proviso which gives the governor the direction to initiate the procedural machinery described therein. Therefore, the first proviso cannot be treated as an independent course of action severable from the option of withholding of assent. The use of the expression as soon as possible in the first proviso makes it clear that the Constitution has imposed a sense of urgency upon the governor and expects him to act with expediency if he decides to declare the withholding of assent. At the same time, that the use of expression may in the first proviso, as explained in State of Punjab quoted supra, does not confer a discretion upon the governor to decide whether to act in accordance with the procedure prescribed in the first proviso. On the contrary, it only denotes that the first proviso would be applicable only when the option of withholding of assent is exercised. In other words, the expression may is used keeping in mind that there are three options that the governor may choose from when a bill is presented to him for assent. Therefore, there is no requirement for construing the expression may as shall, as was vehemently urged on behalf of the petitioner, and the interpretation provided in State of Punjab quoted supra and further explained by us does not merit construing the use of may as shall, as it would result in a logical absurdity insofar as it would make the compliance with the procedure laid down in the first proviso mandatory in the exercise of all three options available to the governor under the substantive part of Article 200 of the Constitution. Para 188. It is also remarkable to take note of the expression if the bill is passed again, which signifies that the ultimate discretion to decide whether the state legislature wants to repass the bill or not continues to remain the prerogative of the state legislature alone. Similarly, the use of the expression with or without amendment denotes that even if the state legislature decides to reconsider the bill, the discretion to repass it with or without the amendment suggested by the governor again continues to be their sole prerogative. In order to obviate any further confusion, we deem to appropriate to clarify that the use of the expression shall reconsider the bill accordingly does not indicate that it is obligatory for the state or legislature to take up the bill for reconsideration. The word shall used in this expression must be read in conjunction with the word accordingly. The use of shall in the context is only for the limited purpose that if the state legislature in a discretion does decide to not allow the bill to fall through by taking it for reconsideration, then the scope of such reconsideration must at the very least encompass the suggestions communicated by the governor in his message. The word shall used herein cannot be singled out and construed devoid of its context. Para 189. The structure of Article 200 is also helpful in discerning the meaning of the content that it holds. There is a substantive part of the provision and there are two provisos to the substantive part. In the substantive part, there are three options for the governor to choose from, each separated by the conjunction or thereby indicating the mutual exclusivity of the three options. If the governor opts for the first option and grants assent to the bill presented to him, the first proviso doesn't come into consideration. Similarly, if the governor chooses the third option and reserves the bill for the consideration of the president, there is no occasion for the operation of first proviso. The second proviso is overarching in nature and provides that in the situation as described therein, the governor can only exercise one option, that is, reserve the bill for the consideration of the president. Para 190. The use of the expression shall declare in the substantive part of Article 200 indicates that the governor is required to make a declaration from the three choices provided to him under the substantive part, and there cannot be any fourth course of action. As soon as assent is granted, the bill becomes an act and there is no scope thereafter for reservation for the consideration of the president or returning back to the state legislature. If reservation for the consideration of the president is declared, then thereafter no returning of the bill to the state legislature can take place unless the president so directs under the proviso to Article 201. Thus, it is only upon the declaration of withholding of assent that the first proviso is animates into action. Para 191. Another important aspect that may be pointed out is that the observations made in Valluri Basavaya Chowdhury quoted supra and Hext quoted supra respectively state that except in the case of a money bill, the governor may withhold assent. A bare reading of Article 200 indicates that there is no restriction in the substantive part that prohibits the governor from declaring that he withholds assent to a money bill, and it is only under the first proviso that such a restriction can be found. Therefore, it is only when the option of the withholding of assent in the substantive part of Article 200 is read along with the first proviso that money bills could be said to be excluded from the purview of withholding of assent under the substantive part of Article 200. Thus, rather than fortifying the argument of the learned Attorney General, the observations made in Valluri Basavaya Chowdhury quoted supra and reiterated in Hext quoted supra only reinforce the intricate, inseparable connection between the exercise of the option of withholding of assent by the governor and coming into operation of the procedure prescribed in the first proviso. The dictum of the above mentioned two decisions in no way renders the decision in state of Punjab quoted supra per incurium and rather bolsters the line of reasoning adopted by this court therein. Para 192. Therefore, the use of the expression the bills the bill falls through unless the procedure indicated in the first proviso is followed should be construed in the context of the entire procedure described in the first proviso. Seen thus, it would mean that the bill would fall through if the bill, having been returned by the governor, is not passed again by the state legislature and presented again to the governor for his assent. The fallacy of the argument canvassed by the learned Attorney General lies in the very fact that he has construed the observations of this court pertaining to compliance with the procedural requirement under the first proviso to mean that the mechanism under the first proviso can only be initiated upon the desire and discretion of the governor. Para 193. This court in Nambudri quoted Supra explained as to how the Para 193. This court in Nambudri quoted Supra explained as to how the state legislature may cause a bill to fall through with which they no longer intend to proceed by not reconsidering and repassing it once it has been returned by the governor with the deceleration of withholding of assent. This court held that the stage of assent could only be arrived at after the stage of reconsideration and repassing by the state legislature has been successfully crossed. The relevant observations read as under. Quote, para 16, ellipsis. Similarly, when it is said that if the bill is passed again, the governor shall not withhold assent therefrom, it does not postulate the existence of the same house because even if it is the successor house which passes, it is true to say that the bill has been passed again because in fact it had been passed on an early occasion. Besides, if the effect of Article 196 is that the bills pending assent do not lapse on the dissolution of the House, then the relevant provisions of Article 200 must be read in the light of that conclusion. In our opinion, there is nothing in the proviso to Article 201 which is inconsistent with the basic concept of democratic government in asking a successor house to reconsider the bill with the amendments suggested by the President because the proviso makes it perfectly clear that it is open to the successor house to throw out the bill altogether. It is only if the bill is passed by the successor house that the stage is reached to present it to the governor or the president for his assent, not otherwise. End of quote. Para 194. There is another way of looking at Article 200. The procedure, as prescribed under the scheme of the provision, involves and envisages the actual motion of a bill from one constitutional authority to another. The article starts with the requirement of the bill having to be mandatorily presented to the governor after it has been passed by the state legislature. Thereafter, there is an obligation on the governor to make a choice from one of the three options provided in the substantive part of the article and also declare such a decision. Here, if assent is declared, then the bill becomes an act, and the government may thereafter take steps to notify the same in the official gazette. If the governor declares that bill is being reserved for consideration of the president as per the second proviso or otherwise, then the bill travels from the governor to the president, whereupon Article 201 comes into play. The mechanism provided in the first proviso also envisages the movement of the bill from the governor to the state legislature and then back to the governor upon being passed again. The expression as soon as possible appearing in the first proviso infuses a sense of urgency and expediency in the mechanism of returning of bills by the governor. It goes without saying that the scheme of Article 200 is characterized by the movement of the bill from one constitutional authority to another, and that too with a sense of expediency. It is trite to say that Article 200 occupies an important role of giving the bills passed by the state legislature the authority of an act. Without the procedure envisaged under Article 200, the bills remain mere pieces of paper, skeletons without any flesh or lifeblood flowing through their veins, mere documentation of the aspirations of the people without any possibility of bringing them into fruition. The only way by which the opinion or the option of withholding of assent provided in the substantive part of Article 200 can be reconciled with the scheme permeating the remainder of the provision is by reading it in conjunction with the first proviso. It is only when the withholding of assent is tempered with the requirement of following the procedure prescribed in the first proviso that the constitutional object of ensuring that the law-making machinery at the state level keeps on running unhindered can be fulfilled. Para 195. Any other reading of the provision that construes the option of withholding of assent without attaching it to the mechanism prescribed in the first proviso would render the very idea of smooth functioning of the lawmaking process nugatory and would vest with the governor untrammeled powers of thwarting the legislative machinery and in effect the will and aspirations of the people whose voices the legislature represents. Para 196. Thus, in light of the aforesaid discussion, it becomes clear that there are only three courses of action available to the governor to choose from when a bill is presented to him for assent under Article 200. The first proviso is not an independent fourth course of action, but intrinsically attached to the option of withholding of assent. In other words, the first proviso is clarificatory and only elaborates the procedure to be followed in case the option of withholding of assent is invoked by the governor. Para 197. The use of expression shall in the substantive part of Article 200 read with the expression as soon as possible used in the first proviso indicates that there is no pocket veto available to the governor while he is exercising the powers under Article 200. As we have also discussed in the subsequent parts of this judgment, inaction on the part of the governor to take a decision when a bill is presented to him under Article 200 is grossly violative of the constitutional scheme of expediency which permeates the provision. Para 198. The governor, in exercise of his powers under Article 200, also does not possess any absolute veto. He is mandated to take a decision from among the three options that are provided in the substantive part of the Article 200. In case of withholding of assent, the governor is bound to follow the procedure prescribed under the first proviso and assent to the bill if it is ultimately presented to him for assent after being repassed by the state legislature. The governor may also reserve certain bills for the consideration of the president. However, in no case has the governor been conferred with the power to veto a bill which is presented to him. He is envisaged as an intermediary stop in the journey of the bill towards becoming an act. When a bill comes to the governor, he may forthwith assent to it or postpone the grant of assent by exercising the option of withholding of assent, but only for so long till the bill comes back to him after reconsideration, or he may forward the bill to the president, whereupon the procedure prescribed under Article 201 is to be followed. Thus, in none of these cases can the governor permanently keep a bill with him without according assent to it, nor can he declare a simpliciter withholding of assent, thereby killing the bill. Section 2. Whether the governor can reserve a bill for the consideration of the president when it is presented to him for assent after being reconsidered in accordance with the first proviso to Article 200, more particularly when he had not reserved it for the consideration of the president in the first instance. Para 199. As discussed in the preceding issue, the governor, in exercise of his powers under Article 200, has three options to choose from. The use of the conjunction or between the three options signifies that the options are mutually exclusive, and once one of the options is exercised by the governor, the other options become unavailable to choose from. Kameshwar Singh, quoted supra, held that there can be no reservation for the consideration of the president once assent is declared, and similarly, there is no requirement for the governor to assent to the bill once the bill, having been reserved for the consideration of the president, has received his assent. Para 200. We have also discussed, in line with the decision in state of Punjab quoted supra, that the option of withholding of assent is attached with the first proviso, and once the governor declares the withholding of assent, the entire mechanism which is laid down in the first proviso itself has to follow suit. Thus, the first proviso to Article 200 is a complete code in itself as regards the procedure which is to be followed once the governor withholds assent, and the rest of the article has no applicability thereafter. Para 201. It is also interesting to note that the expression withhold assent has been employed in the substantive part of Article 200. The literal meaning of the expression withhold, as defined in a number of dictionaries, is to keep back, to keep in one's possession what belongs to or is due to others, to hinder, to prevent, to defer, to postpone, to detain, to keep under control, to retain, to keep from doing something, to refrain from doing something. Thus, it would not be incorrect to construe that the option of withholding of assent has been provided to the governor under the substantive part only with a view to defer or to postpone the grant of assent to a bill. Withholding of assent cannot be construed to be the same as denying of assent or as conferring a power in the governor to veto a legislation passed by the state legislature, which would be against the very fundamentals of a representative democracy. Para 202. Further, the scope of this deferment of assent by the governor has been made subject to the procedure laid down in the first proviso. The procedure laid down in the first proviso ensures that the withholding of assent does not become analogous to a pocket veto. The use of the expression "if the bill is passed again by the House or Houses with or without amendment" in the first proviso clearly indicates that the role of the governor under the first proviso has been characterized as recommendatory in nature, and that these suggestions do not bind the legislature. Further, the expression "the governor shall not withhold assent therefrom" in the first proviso leaves no scope for the governor to take any course of action other than discontinuing the withholding of assent, which by necessary implication means to accord assent to the bill. The expression also indicates that there is strict constitutional prohibition against the governor to not withhold assent to the bill. Para 203. What follows from the aforesaid discussion is that once the option of withholding of assent is exercised by the governor, the mechanism under the first proviso is set into motion to the exclusion of everything else envisaged under the article. This is in view of the maxim expressio unius est exclusio alterius, that is, the expression of one thing is the exclusion of another. Once the mechanism under the first proviso is set into motion and the various stages are complied with, the only possible manner in which the mechanism prescribed under the first proviso can conclude is by the governor granting assent to the bill. Thus, there is no scope for the governor to reserve a bill for the consideration of the president once it is presented to him for reconsideration after compliance with the procedure laid down in the first proviso. Para 204. However, for the sake of completeness, we deem it necessary to discuss a possible scenario wherein the governor may have the power to reserve the bill for the consideration of the president even after it is repassed by the state legislature and presented to him for assent. Say, for instance, in a particular case, the governor withholds assent to a bill which is presented to him and returns it to the House or the Houses together with a message requesting them to reconsider certain aspects of the bill or introduce certain amendments desirable thereto. However, the House or the Houses, in the process of reconsideration, introduce certain changes which were not suggested by the governor in the message which he sent together with the bill. In such a scenario, the House or Houses cannot be said to have reconsidered the bill accordingly, which is a mandatory condition prescribed under the first proviso. If the bill which is presented to the governor for assent in the second round could be said to have been reconsidered by the House or Houses on wholly different and new grounds, and if those changes are of such a nature where a reservation for the consideration of the president may be desirable, then the governor would not be precluded from reserving the bill for the consideration of the president. Para 205. However, if the bill is repassed by the House or Houses without amendments or only with such amendments as were suggested by the governor in his message, then the procedure prescribed under the first proviso could be said to be fully complied with, and the governor would be bound to signify his assent thereto and would be precluded from reserving the bill for the consideration of the president. Para 206. We say so because the procedure laid down in the first proviso cannot be construed as giving the state legislature the unfettered power to introduce changes to the bill which alter its very nature or which, for instance, fall foul of the second proviso to Article 200. In such a scenario, the governor would have all the three options which are available to him when a bill is presented to him in the first instance. However, whenever the House or Houses reconsider the bill accordingly, that is, in accordance with the suggestions of the governor, and pass it with or without amendments, the governor is bound to act as per the clear constitutional directive laid down in the first proviso. Para 207. Sorry, as we shall also discuss later, any reservation of a bill by the governor for the consideration of the president on the ground that the bill was not reconsidered as per the procedure prescribed in the first proviso would be subject to judicial scrutiny. Para 208. Coming to the facts of the present case, out of 12 bills which are the subject matter of the present petition, two were reserved by the governor for the consideration of the president in the first instance of their presentation. As regards the remaining 10 bills, the governor declared a withholding of assent. However, the bills were returned without any message as is envisaged under the first proviso. What stands out as a glaring omission on the part of the governor is that the day on which the withholding assent was declared, the decision in state of Punjab quoted supra had already been passed and even the notice in the present petition had been issued. Thus, it was expected of the governor that he would not declare a simpliciter withholding of assent of the bills without specifying the reasons for such withholding and also without making recommendations as regards the desirability of introducing any amendments by the state legislature while reconsidering the bills. Para 209. In light of the language of Article 200 and also keeping in mind its interpretation by this court in state of Punjab quoted supra, there was no room for the governor to declare a simpliciter withholding of assent without taking recourse to the first proviso, as that virtually amounts to the exercise of absolute veto by the governor, a power which is conspicuously absent from our constitutional scheme. Para 210. In the absence of any message under the first proviso by the governor, the state legislature was left with no other option but to proceed on the assumption that the bills were required. Sorry. Para 210. In the absence of any message under the first proviso by the governor, the state legislature was left with no other option but to proceed on the assumption that the bills were required to be reconsidered in its entirety. The state legislature proceeded on this assumption, and the said 10 bills were reconsidered in a special sitting and were passed without any material changes and presented to the governor on the same day. Thereafter, the governor, rather than giving his assent to the bills, went on to reserve the bills for the consideration of the president on the ground that the bills were repugnant to entry 66 of the list 1 of the schedule 7 to the constitution. Para 211. For the reasons that we have assigned in our foregoing discussion, we are of the view that the governor could not have reserved the bills for the consideration of the president once they were reconsidered by the state legislature and presented to him without any amendments, particularly when the governor sent back the bills to the state legislature without any message on an earlier occasion. As a natural consequence of the reservation of the bills for the consideration of the President, having been found out to be in contravention of the procedure prescribed under Article 200 of the Constitution, and thus illegal and void, any subsequent decision taken by the President on those bills would also be non est and is thus declared to be void ab initio. Section 3. Whether there is an express constitutionally prescribed time limit within which the governor is required to act in the exercise of his powers under Article 200 of the Constitution. Para 212. It was argued by the petitioner that the governor, in exercise of his powers under Article 200, is required to act promptly, and the absence of any prescribed time period should not be construed as allowing the governor the liberty to act on his own free will and volition. It was also submitted that this expression, as soon as possible, appearing in the first proviso, places an obligation on the governor to act promptly and with expedience. Para 213. The petitioner also placed reliance on the recommendations made by the Sarkaria Commission and the Punchi Commission to argue that the court should read in some time limit into the scheme of Articles 200 and 201 respectively to prevent inaction on the part of the governor and the president. Para 214. Refuting the contention of the petitioner, the learned Attorney General argued that in the absence of any prescribed time limit in the text of the provision, it would not be open to the court to read in a time limit, and the only way to do so would be by way of a constitutional amendment. He placed reliance on the decision of this court in Nambudri, quoted supra, to argue that this court had expressly rejected the idea that there is a time limit which circumscribes the exercise of functions of the governor under Article 200. Para 215. The arguments advanced before us present an interesting question whether it would be open to the courts to read in a time limit for the exercise of a power by a constitutional authority where no such time limit is prescribed by the Constitution. We have expressly held during the course of answering the previous issue that the scheme of Article 200 does not envisage either the exercise of a pocket or an absolute veto by the governor. The use of the expression shall in the substantive part indicates that the governor is under an obligation to choose from one of the three options that are made available to him. By virtue of the first proviso attaching itself to the option of withholding of assent, as discussed earlier, the possibility of an absolute veto is also ruled out, as the governor must assent to the bill once it is presented to him after the procedure prescribed in the first proviso is complied with. Para 216. However, unlike many countries across the globe wherein a provision for deemed assent upon the expiry of the specified time period has been made, there is no such provision in our Constitution. The only manner in which a temporal imperative has been weaved into the scheme of Article 200 is by the use of the expression as soon as possible in the first proviso. The said expression, which also appears in Article 111 of the Constitution, was the subject of some debate in the Constituent Assembly. Para 217. Article 111, which provides for the President's assent to bills passed by Parliament, was originally numbered as Article 91 under the draft Constitution, and it provided a time limit of 6 weeks to the President to send back the bill to the Houses for reconsideration. The draft article read as follows. When a bill, quote, when a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom, provided that the President may, not later than 6 weeks after the presentation to him of a bill for assent, return the bill if it is not a money bill to the Houses with a message requesting that they will reconsider the bill or any specified provision thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and the Houses shall reconsider the bill accordingly. End of quote. Para 218. During the Constituent Assembly debates, Dr. B.R. Ambedkar moved an amendment to substitute the expression not later than 6 weeks with as soon as possible. Further, in the debate, Sri Naziruddin Ahmad advocated for a change in the aforesaid amendment and sought to substitute the term as soon as possible with as soon as may be. His contention rested on the reasoning that the phrase as soon as possible, which was introduced by Dr. Ambedkar in his amendment in place of the original wording used in Article 91, that is, not later than 6 weeks, imposed an unduly stringent obligation upon the President. He was of the opinion that as soon as possible mandates immediate action, thereby curtailing the President's scope to engage in a careful and deliberate review of the bill presented for assent. He expressed concern that such a rigid constraint could give rise to hasty decisions devoid of any careful examination of the presented bill. In his view, the formulation ran the risk of undermining the quality of the President's judgment under Article 111. He expressed his opinion as follows. Quote, ellipsis, the proviso is to the effect that the President may, as soon as possible after the presentation of the bill, return the bill, and so on. I want to make it as soon as may be. If we leave it exactly as Dr. Ambedkar would have it, it leaves no margin. As soon as possible means immediately. Possibility, which means physical possibility, is the only test. It may leave no breathing time to the Vice President. The words maybe give him a reasonable latitude. It would mean reasonably practicable. This is the obvious implication. That is the only reason why I have suggested the amendment. End of quote. To avoid the aforesaid possibility, Sri Naseeruddin Ahmad proposed the adoption of as soon as may be, which he interpreted to mean as soon as is reasonably practicable. In his opinion, this change would allow the President greater flexibility and sufficient time to thoroughly examine the provision of the bill presented to him. Such freedom would prove particularly valuable when the President contemplates returning the bill to the Houses for reconsideration, especially in circumstances where amendments might be recommended. The essence of Sri Ahmad's amendment was to safeguard the President's ability to render well-reasoned and thoughtful decisions without any rigid time constraints. Para 220. Sri P.S. Deshmukh expressed his opposition to the amendment proposed by Dr. B.R. Ambedkar, deeming the suggested substitution of the words as unnecessary. He, on the other hand, argued that the original phrasing, particularly the expression not later than 6 weeks, ought to remain unaltered as it established a precise time frame for the President to act accordingly. He further argued that this specific time frame mandated that the President must convey his decision to return the bill for reconsideration as expeditiously as possible and in no event beyond 6 weeks. He opined that preserving the words not later than 6 weeks was quintessential to ensure timely action, thereby preventing undue delays in the legislative process to send the bills back to the Houses for reconsideration. Para 221. Sri H.V. Kamath vehemently opposed the amendment put forward by Dr. Ambedkar. Advocating for expeditious and timely action, he argued that, quote, in human nature, if you will permit me to say so, unless there is a compelling sense of duty or service, there is always a tendency to procrastinate, end of quote. It was his opinion that such tendencies to procrastinate must be rooted out by infusing a standard of duty or service to ensure timely action on part of the President. He further opined that there exists no assurance that every President of India will consistently adhere to the principle of timely action in legislative processes. Therefore, according to him, it was very necessary that the Constitution should provide specifically a time limit for a contingency of this nature. He believed the phrase as soon as possible to be vague, purposeless, and meaningless, and argued that such vague phrases have no place in a provision of such an important nature. Para 222. In light of the debate which took place on 20th May 1949, the proposed amendment to Article 91 was adopted by the Assembly, thereby substituting the expression not later than 6 weeks with as soon as possible, and the same came to be added to the Constitution. Paragraph 223. What can be postulated from this discussion of the relevant Constituent Assembly debates is that although our constitutional makers expressed their concerns for the possibility of an undue delay in the legislative process on account of the human nature to procrastinate, yet they nevertheless proceeded to adopt the phrase as soon as possible in the original article. 91. This adoption and amendment of draft Article 91 reflects a sense of inherent trust reposed by the Constituent Assembly that the President would execute his functions as enshrined under Article 111 of the Constitution in a timely and efficient manner. Para 224. The expression also came to be adapted mutatis mutandis in Article 200. The experience of the working of the Constitution, more particularly Article 200, has shown that the apprehensions expressed by some of the members of the Constituent Assembly have unfortunately proven to be prophecy. As we have discussed in the preceding paragraphs, one of the prominent grievances of the state governments, as recorded by the Sarkaria Commission and Punchi Commission reports, was that the exercise of the power under Article 200 by the governor, not being a time bound process, leads to significant legislative delay and that certain bills are withheld in the governor's secretariat for years. Para 225. Not taking any action on the bills for an unreasonable and prolonged period of time virtually vests the governor with the power of pocket veto, and the same cannot be held to be permissible within our constitutional scheme. Dr. Singhvi had submitted during the course of his arguments that there is no scope for the governor to decide not to decide. Article 200 being the final step in the process of the birth of a legislative enactment, the stage wherein life is breathed into an otherwise lifeless document, cannot be interpreted in a manner which allows the governor to remain silent and exhibit inaction upon the bills which are submitted to him after having received the approval of the majority of the state legislature. Para 226. This court in Durgapada Ghosh versus State of West Bengal, reported in 1972 to SCC 656, whilst dealing with a writ in the nature of habeas corpus, was called upon to examine the meaning and import of the expression as soon as may be appearing in Article 22, Clause 5 of the Constitution and its significance in communication of the grounds of detention and disposal of the representation of the detenu. In the said case, the detenu came to be arrested and put in preventive detention in December 1971. The detenu moved a representation which was received in early January 1972. However, his representation came to be considered by the state government therein only in February 1972, and his detention was confirmed and communicated in March 1972. The detenu challenged the order of preventive detention passed against him on the ground that there was an inordinate delay of almost 2 months on part of the state government in considering his representation, even though the same had been received in January itself. This court held that the aforesaid expression must be seen in the context of the scheme underlying Article 22, more particularly the importance that it occupies in the constitutional setup as regards the personal freedom of an individual, and in a manner whereby the provision does not lose both its purpose and meaning. The words as soon as may be in such context implies anxious care on the part of the authority concerned to perform its duty in this respect as early as practicable without avoidable delay. The course of action which is expected from the concerned authority, being communication of the grounds of arrest and disposal of the representation, was required to be considered with a sense of urgency and must be done with due promptitude or expedition and with reasonable dispatch. It was further held that although there is no definite time limit which can be laid down within which such actions must be done, Yet, at the same time, whether the appropriate authority had disposed of its obligation as expeditiously as possible ought to be looked into, keeping in mind the peculiar facts and circumstances of each case. It further held that such constitutional obligations cannot be ignored or justified on reasons of administrative delay, except where it is shown that ample arrangements were made to cope with the situation that led to a delay and a certain degree of priority was accorded. The relevant observations read as under quote para 7. Now it is not disputed before us that on the question of delay in considering the representation by the state government, no hard and fast rule can be laid down, and it is a matter which falls for decision on the facts and circumstances of each case. It may in this connection be pointed out that in Jayanarayan case, the writ petition was referred to a bench of 5 judges to consider as to what would be the question of period within which the state government could dispose of the representation of the detainee, because it was felt that there was an apparent conflict between Shyamal Chakrabarti versus Commissioner of Police Calcutta and Khairul Haq versus State of West Bengal. After considering the various decisions on the point, this court expressly concluded thus. Quote, emphasis added. No definite time can be laid down within which a representation of detenu should be dealt with, save and except that it is a constitutional right of a detenu to have his representation considered as expeditiously as possible. It will depend upon the facts and circumstances of each case whether the appropriate government has disposed of the case as expeditiously as possible, for otherwise, in words of Sheila Justice, who spoke for this court in the case of Khairul Haq, it is obvious that the obligation to furnish the earliest opportunity to make a representation loses both its purpose and meaning. End of quote. Para 8. The scheme underlying Article 22 of the Constitution highlights the importance attached in our constitutional setup to the personal freedom of an individual. Sub Articles 1 and 2 refer to the protection against arrest and detention of a person under the ordinary law. Persons arrested or detained under a law providing for preventive detention are dealt with in sub articles 4 to 7. Sub article 5 says that when a person is detained in pursuance of an order under a law providing for preventive detention, the grounds on which the order is made have to be communicated to the person concerned as soon as may be, and he has to be afforded earliest opportunity to represent against the order. The object of communicating the grounds is to enable the detainee to make his representation against the order. The words as soon as may be in the context must imply anxious care on the part of the authority concerned to perform its duty in this respect as early as practicable without avoidable delay. Similarly, when the representation is made, it is in the fitness of things that the said representation should be considered with the same sense of urgency with which the grounds are intended to be communicated to the detainee. Emphasis. That is the only way in which the purpose for which the earliest communication of the grounds to the person concerned is provided can be achieved. The representation must, therefore, be considered with due promptitude or expedition and without avoidable delay, in other words, with reasonable dispatch. As held by this court in Jayanarayan case, the representation should be considered as expeditiously as possible. As the question of delay in considering this representation falls for determination on the facts and circumstances of each case, the binding force of a past precedent for a later case would largely depend on the degree of close similarity of the circumstances dealt with therein. Ellipsis, end of quote. Emphasis applied. Para 227. In Kesham, quoted Supra, the question that arose before this court was whether courts can direct the Speaker to decide disqualification petitions pending before it within a reasonable period of time, and this court, speaking eruditely through R.F. Nariman, Justice, answering the aforesaid question in an affirmative, held as under. Number 1. First, that the Speaker, being the quasi-judicial authority for the purposes of the 10th schedule is duty bound to take a decision of disqualification petitions within a reasonable time. Any failure of the speaker in exercising his jurisdiction or refraining from deciding such petition within a reasonable time would be an error that would attract the scrutiny of the courts in judicial review, notwithstanding the exclusive jurisdiction to the exclusion of the courts that has been conferred upon the speaker in terms of paragraph 6 of the 10th schedule. The relevant observations read as under. Para 24, quote, it is clear from a reading of the judgment in Rajendra Singh Rana and in particular the underlined portions italicized herein of paras 40 and 41 that the very question referred by the two judge bench in S.A. Sampath Kumar has clearly been answered stating, emphasis, that a failure to exercise jurisdiction vested in a speaker cannot be covered by the shield contained in para 6 of the 10th schedule, and that when a speaker refrains from deciding a petition within a reasonable time, there was clearly an error which attracted jurisdiction of the High Court in exercise of the power of judicial review. Emphasis supplied. Item 2. Secondly, it observed that although paragraph 6 of the 10th schedule vests the Speaker with an exclusive jurisdiction to decide disqualification petitions and ousts the reaches, reach of courts in such matters, yet it does not mean that there is no scope of judicial review by the courts or that the power to pass any directions to the Speaker acting under the 10th schedule does not exist. It was observed that the true purport of such exclusive jurisdiction was only to ensure that no obstacle comes in the way of the Speaker in deciding such petitions by way of injunctions from the courts. However, it by no means interdicts the exercise of judicial review in aiding a prompt decision on such disqualification petitions to ensure that the Speaker decides these issues within a reasonable period. The relevant observations read as under. Quote, para 30. A reading of the aforesaid decisions, therefore, shows that what was meant to be outside the pale of judicial review in para 110 of Kifotho Holohan are quia timet actions in the sense of injunctions to prevent the speaker from making a decision on the ground of imminent apprehended danger, which will be irreparable in the sense that if the speaker proceeds to decide that the person be disqualified, he would incur the penalty of forfeiting his membership of the House for a long period. Paras 110 and 111 of Quixote Holohan do not therefore in any manner interdict judicial review in aid of the speaker arriving at a prompt decision as to disqualification under the provisions of the 10th schedule. Indeed, the speaker in acting as a tribunal under the 10th schedule is bound to decide disqualification petitions within a reasonable period. Ellipsis and end of quote. Item 3. Lastly, it held that although what would be a reasonable period for deciding such petitions by the Speaker largely depends on the facts of each case, yet, where there are no exceptional circumstances, the Speaker should arrive at a decision within an outer time limit of 3 months so that the above constitutional objective of anti defection under the 10th schedule is not defeated. The relevant observations read as under. Quote, paragraph 30, ellipsis, followed by, what is reasonable will depend on the facts of each case, but absent exceptional circumstances for which there is good reason, a period of 3 months from the date on which the petition is filed is the outer limit within which disqualification petitions filed before the Speaker must be decided if the constitutional objective of disqualifying persons who have infracted the 10th schedule is to be adhered to. This period has been fixed keeping in mind the fact that ordinarily the life of the Lok Sabha and the Legislative Assembly of the states is 5 years, and the fact that persons who have incurred such disqualification do not deserve to be MPs, MLAs, even for a single day as found in Rajendra Singh Rana if they have infracted the provisions of the 10th schedule. End of quote. Emphasis supplied. Para 228. The aforesaid view, as reiterated in Telangana versus Governor of Telangana, reported in 2024 1 SCC 405, wherein this court, while dealing with a similar issue pertaining to the pendency of a few bills before the Governor of Telangana, held that the expression as soon as possible in Article 200 has significant constitutional content and must be borne in mind by the constitutional authorities. The relevant observations read as under. Quote, Para 2. The first proviso to Article 200 states that the Governor may, as soon as possible after the presentation of the bill for assent, return the bill if it is not a money bill, together with a message for requisition to the House or Houses of the State Legislature. Emphasis. The expression as soon as possible has significant constitutional content and must be borne in mind by constitutional authorities. Emphasis applied. Para 229. In Ramchand, quoted Supra, certain parcels of land had been demarcated and declared for compulsory acquisition via a non-notification sometime between the years 1959 to 65. However, the awards for compensation came to be passed almost 14 years later in the year 1980. These awards came to be challenged before this court on the ground that since the statute in question provides for payment of compensation in respect of the acquisition made at the market value of the land as it stood at the time of publication of the notification for declaration, the same necessarily meant that compensation ought to be paid expeditiously and without delay. This court held that although the legislature, by way of an amendment, has now prescribed a time limit for making an award, yet it does not mean that prior to such amendment there was no time limit for payment of compensation or that an award could be passed by the authorities at their own pace and leisure. It held that where for an exercise of any power no time limit has been prescribed, such power has to be exercised within a reasonable period of time. It further held that, sans any fixed time limit, such powers cannot be exercised or subjected to delay in a manner that violates or circumvents the object of the statute and the constitutional mandate under Article 31A of timely acquisition and adequate compensation, respectively. The relevant observations read as under. Quote, Para 14. The Parliament has recognized and taken note of the inaction and non-exercise of the statutory power on the part of the authorities enjoined by the provisions of the Act to complete the acquisition proceedings within a reasonable time, and because of that now a time limit has been fixed for making of the award, failing which the entire proceeding for acquisition shall lapse. Emphasis. But can it be said that before the introduction of the aforesaid amendment in the Act, the authorities were at liberty to proceed with the acquisition proceedings, irrespective of any schedule or time frame, and to complete the same as and when they desired? It is settled that in a statute where for exercise of power no time limit is fixed, it has to be exercised within a time which can be held to be reasonable. This aspect of the matter can be examined in the light of second proviso to Article 31A of the Constitution, which in clear and unambiguous terms prohibits making of any law which does not contain a provision for payment of compensation at a rate which shall not be less than the market value thereof. The Act is consistent with the second proviso to Article 31A because it provides for payment of compensation at the market value of the land acquired. But whether the constitutional and statutory requirement of the payment of the market value to the persons whose lands have been compulsorily acquired is not being circumvented and violated by keeping the land acquisition proceedings pending for more than a decade and a half without making the awards and paying the compensation which has been pegged to the dates of notifications under subsection 1 of section 4 of the Act, which in the present cases has been issued 14 to 21 years before the making of the awards. Ellipsis, end of quote. Emphasis supplied. Para 230. In AG Pardiwala, quoted Supra, the facts germane for our discussion are that the appellant convict therein had filed a mercy petition under Article 161 to the Governor in December 2015. The State Cabinet recommended the grant of remission to the Governor in 2018. However, the Governor did not take any decision on the mercy petition for 2 years despite receiving the recommendation of the State Cabinet. Thereafter, upon a direction of this court, the Governor in 2021 by an order forwarded the mercy petition of the appellant to the President, citing that the Union is the appropriate authority to decide the same. This reference came to be challenged before this court, wherein it was held as under. Item 1. First, it was held that the limits within which the executive government can function under the Indian Constitution can be ascertained without much difficulty by reference to the form of the executive which our Constitution has set up. End of quote. The court observed that although the governor is the head of the executive in the state, yet in actuality it is the Council of Ministers that carries on the executive government. It held that as per Article 163, the governor shall exercise his functions provided under different provisions of the Constitution only under the aid and advice of the Council of Ministers, except where he under the Constitution has been expressly authorized to exercise such functions in his discretion. This court, speaking through L. Nageshwar Rao, Justice, described this relation of the governor and the Council of Ministers as a hyphen which joins, a buckle which fastens the legislative part of the state to the executive part. End of quote. The relevant observations read as under. Quote, para 18, the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of an offence against any law related to which the executive power of the state extends is vested in the governor under Article 161 of the Constitution. Article 162 makes it clear that the executive power of the state shall extend to matters with respect to which the legislature of the state has power to make laws. Article 163 of the Constitution provides that there shall be a Council of Ministers with the Chief Minister at the head to aid and advise the Governor in the exercise of his functions, except insofar as he is by or under his Constitution required to exercise his functions or any of them in his discretion. Para 19. The limits within which the executive government can function under the Indian Constitution can be ascertained without much difficulty by reference to the form of the executive which our Constitution has set up. Our Constitution, though federal in its structure, is modelled on the British parliamentary system, where the executive is deemed to have the primary responsibility for the formulation of governmental policy and its transmission into law, though the condition precedent to the exercise of this responsibility is its retaining the confidence of the legislative branch of the state. The governor occupies the position of the head of the executive in the state, but it is virtually the council of ministers in each state that carries on the executive government. In the Indian Constitution, therefore, we have the same system of parliamentary executive as in England, and the council of ministers consisting, as it does, of the members of the legislature is, like the British cabinet, a hyphen which joins, a buckle which fastens the legislative part of the state to the executive part. Para 20. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in few spheres where the governor is required by or under the constitution to exercise his functions in his discretion. Wherever the Constitution requires the satisfaction of the President or the Governor for the exercise of any power or function by the President or the Governor, as the case may be, as for example in Articles 123, 213, 311, Clause 2, Proviso C, 317, 352, Clause 1, 356 and 360. The satisfaction required by the Constitution is not the personal satisfaction of the President or of the Governor, but is the satisfaction of the President or of the Governor in the constitutional sense under the cabinet system of government. It is the satisfaction of the Council of Ministers on whose aid and advice the President or the Governor generally exercises his powers and functions. Para 21. Even though the governor may be authorized to exercise some functions under the different provisions of the Constitution, the same are required to be exercised only on the basis of the aid and advice tendered to him under Article 163, unless the governor has been expressly authorized by or under a constitutional provision to discharge the function concerned in his own discretion. End of quote. Item 2. Secondly, it is observed that the law is clear and explicit. The advice of the state cabinet is binding on the governor when it comes to the exercise of powers under Article 161. In the absence of any other provision under the Constitution or any statute in this regard, the governor could not have deviated from the binding recommendations of the state cabinet and referred the mercy petition to the president. It was held that such an action is contrary to the constitutional scheme. The relevant observations read as under. Para 24. The law laid down by this court as detailed above is clear and explicit. The advice of the state cabinet is binding on the governor in matters relating to commutation, remission of sentences under Article 161. No provision under the Constitution has been pointed out to us nor any satisfactory response tendered as to the source of the governor's power to refer a recommendation made by the state cabinet to the President of India. In the instant case, the governor ought not to have sent the recommendation made by the state cabinet to the President of India. Such action is contrary to the constitutional scheme elaborated above. Ellipsis. Emphasis. It is relevant to point out that the recommendation made by the state cabinet was on 9th of September 2018, which remained pending before the governor for almost 2.5 years without a decision being taken. It was only when this court started inquiring about the reason for the decision being delayed, the governor forwarded the recommendation made by the state government for remission of the appellant sentence to the President of India. End of quote. Emphasis applied. Item 3. Thirdly, as regards the inaction of the governor in deciding the mercy petition for more than 2 years, this court held that although there is a certain degree of immunity with respect to the exercise of powers by the governor under the constitution, yet it is an equally settled position that the courts have the power to judicially review the functioning of the governor on certain grounds. It held that a non-exercise of these powers, such as under Article 161, is one such ground for the exercise of judicial review, as the said provision pertains to the liberty of individuals, and any inexplicable delay not on account of the prisoners is inexcusable. The relevant observations read as under. Quote, para 24, it is relevant to point out that the recommendation made by the state cabinet was on 9th of September 2018, which remained pending before the governor for almost 2.5 years without a decision being taken. It was only when this court started inquiring about the reason for the decision being delayed, the governor forwarded the recommendation made by the state government for the remission of the appellant sentence to the President of India. Para 25. Emphasis. We are fully conscious of the immunity of the governor under the constitution with respect to the exercise and performance of the powers and duties of his office or for any act done or purported to be done by him in the exercise and performance of such powers and duties. However, as held by this court in numerous decisions, this court has the power of judicial review of orders of the governor under Article 161, which can be impugned on certain grounds. Non-exercise of the power under Article 161 is not immune from judicial review, as held by this court in Epuru Sudhakar vs. State of AP. Given petitions under Article 161 pertain to the liberty of individuals, inexplicable delay not on account of the prisoners is inexcusable, as it contributes to adverse physical conditions and mental distress faced by a prisoner, especially when the state cabinet has taken a decision to release the prisoner by granting him the benefit of remission, commutation of his sentence. End of quote. Emphasis applied. Item 4. Lastly, as regards the contention of the respondents that the decision of the governor to forward the mercy petition to the president was done in exercise of his discretion owing to the irrational recommendation of the cabinet in line with the ratio of MP special police quoted supra, this court held that the aforesaid decision would not be applicable since there is nothing to make out a case of irrational or non-consideration of relevant factors by the state government to warrant the governor exercising his discretion and deviating from their recommendations as laid down in MP special police quoted supra. The relevant observations read as under. Quote, para 29. We are afraid that the judgment of this court in MP special police establishments is not applicable to the facts of the present case. No arguments have been put forth to make out a case of non-consideration of relevant factors by the state cabinet or of the state cabinet having based its recommendation on extraneous considerations. Moreover, in the said case, the governor had not taken a Moreover, in the said case, the governor had taken a decision which was subsequently challenged, unlike the present case, where the governor has merely forwarded the recommendation made by the state cabinet to the President of India. End of quote. Accordingly, this court held as under. Quote, para 38. In conclusion, we have summarized our findings below. 38.1. The law laid down by a scatena of judgments of this court is well settled that the advice of the state cabinet is binding on the governor in the exercise of his powers under Article 161 of the Constitution. 38.2 non emphasis non exercise of the power under article 161 or inexplicable delay in exercise of such power not attributable to the prisoner is subject to judicial review by this court, especially when the state cabinet has taken a decision to release the prisoner and made recommendations to the governor to this effect. 38.3 The reference of the recommendation of the Tamil Nadu cabinet by the governor to the President of India 2.5 years after such recommendation had been made is without any constitutional backing and is inimical to the scheme of our constitution, whereby the governor is but a shorthand expression for the state government as observed by this court. 38.4 The judgment of this court in MP Special Police Establishment has no applicability to the facts of this case, and neither has any attempt been made to make out a case of apparent bias of the state cabinet or the state cabinet having based its decision on irrelevant considerations which formed the fulcrum of the said judgment. Emphasis. End of quote. Emphasis supplied. Para 231. What is discernible from a reading of the decisions discussed above is that despite there being no prescribed time limit for the governor to take a decision under Article 200, the provision cannot be read in a manner which allows the governor to not take action upon bills which are presented to him for assent and thereby delay and essentially roadblock the law-making machinery in the state. As held in AG Perarivalan quoted supra, the inaction of the governor would be subject to judicial review, and in the absence of any cogent reasons for the delay, it would be open to the courts to issue directions for a time-bound decision on a case-to-case basis. Para 232. In Purushothaman Nambudri quoted supra, two questions fell for the consideration of this court. First, whether a bill which has been pending for assent before the president or the governor could be said to have lapsed with the dissolving or dissolution of the state legislative assembly, and secondly, whether Article 200 mandates that a bill sent back by the president or the governor for reconsideration must be looked into by the very same house that originally passed it. Before looking into the effect of the dissolution of the House on bills pending before the Governor for assent, the Court, while examining the effect of prorogation of the House on the bills pending before the state legislature, observed that Article 196 of the Constitution, that deals with the introduction and passing of bills in the state legislature, reinforces that the parliamentary form of government established under the Constitution is markedly different from Parliament in England, inasmuch as Clause 3 of Article 196 explicitly stipulates that a bill pending in the legislature of a state will not lapse by reason of the prorogation of the House or Houses thereof. Para 233. Thereafter, the court observed that Article 196, Clause 5 provides for three categories of cases where a bill pending before Legislative Assembly would lapse upon its dissolution. Those are as follows. Item A bill pending before the Legislative Assembly of a unicameral state legislature. Item B, a bill pending before the Legislative Assembly of a bicameral state legislature. Or item C, a bill which originated in the Legislative Assembly and is yet to reach the Legislative Council. Para 234. In light of the aforesaid, the court reached the conclusion that since Article 196 only stipulates as to when a bill pending in the state legislature could be said to have lapsed, be it the Legislative Assembly or the Legislative Council, any bill which has been passed by the state legislature and is pending assent of the governor or president would be outside the ambit of the doctrine of lapse of pending business as contained in Article 196, Clause 5 of the Constitution. Had the intent of the framers of the Constitution been otherwise, a specific provision to that effect providing for lapse of a bill awaiting assent would have been inserted. The natural corollary of the omission of the aforesaid is that Article 196, Clause 5 is exhaustive in nature, and only the circumstances enumerated therein would result in any lapse of a pending bill, as otherwise there was no need for inserting Clause 5 in Article 196 after having already provided the situations where a bill would not lapse in Clauses 3 and 4 of the Constitution respectively. Para 235. Thereafter, the court adverted to Articles 200 and 201 of the Constitution, respectively, in order to determine the effect of dissolution on bills pending the assent of the governor or the president. Adverting to the procedure prescribed under Articles 200 and 201 respectively, the court noted that both the articles do not prescribe a time limit within which the governor or president are required to come to a decision on the bill presented to him, unlike other provisions in the Constitution where it was felt necessary and expedient to prescribe a time limit, such as Articles 197, Clause 1, Subclause B, and Clause 2, Subclause B, respectively. This, in the opinion of the court, necessarily meant that the omission in prescribing a time limit within which the governor or the president should reach a decision under Articles 200 and 201 respectively suggests that the framers of the Constitution knew that a bill pending the assent of the governor or the president does not stand the risk of getting lapsed on the dissolution of the assembly. Any other contrary view would lead to a chilling effect whereby a fair number of bills which may have been passed by the Assembly during the last months of its existence may be exposed to the risks of lapse consequent to the dissolution of the Assembly unless assent is either withheld or granted before the days of dissolution, which could not have been the intention in the absence of a time limit under Articles 200 and 201 respectively. The relevant observations read as under quote, para 15. It is clear that if a bill pending the assent of the governor or the president is held to lapse on the dissolution of the assembly, it is not unlikely that a fair number of bills which may have been passed by the assembly, say during the last 6 months of its existence, may be exposed to the risk of lapse consequent on the dissolution of the assembly unless assent is either withheld or granted before the date of the dissolution. If we look at the relevant provisions of the Articles 200 and 201 from this point of view, it would be significant that neither article provides for a time limit within which the governor or the president should come to a decision on the bill referred to him for his assent. Where it appeared necessary and expedient to prescribe a time limit, the Constitution has made appropriate provisions in that behalf. End of emphasis. Wide Article 197, Clause 1, Subclause B, and Clause 2, Subclause B. In fact, the proviso to Article 201 requires that the House to which the bill is remitted with a message from the President shall reconsider it accordingly within a period of 6 months from the date of the receipt of such message. Emphasis. Therefore, the failure to make any provision as to the time within which the governor or the president should reach a decision may suggest that the constitutional makers knew that a bill which was pending the assent of the governor or the president did not stand the risk of lapse on the dissolution of the assembly. That is why no time limit was prescribed by Articles 200 and 201. Therefore, in our opinion, the scheme of Articles 200 and 201 supports the conclusion that a bill pending the assent of the governor or the president does not lapse as a result of the dissolution of the assembly, and that incidentally shows that the provisions of Article 196 sub clause 5 are exhaustive. End of emphasis. End of quote. Emphasis supplied. Para 236. What is clearly discernible from a plain reading of the aforesaid decision is that the observations as regards the absence of a time limit under Articles 200 and 201 respectively were made in the context of the impact of dissolution of the state legislature on the bills which were pending assent from the governor. Applying the doctrine of constitutional continuity of the state legislature as an institution and the absence of any specific time limit prescribed under Article 200, the court arrived at a finding that such bills would not lapse by virtue of dissolution of the state legislature. It is important to note that the observations in Nambudri Court Supra were not made in the context of the expediency with which the governor is expected to act in discharge of his duties under Article 200. Further, while this court said that there was no prescribed time limit in Article 200, it held that the reason for this was that the framers of the Constitution knew that such a bill would not lapse automatically with the dissolution of the House. It was never observed or even remotely indicated by this court that the exercise of power by the governor under Article 200 was not of an urgent or expedient character and thus could be exercised even beyond reasonable time. Para 237. It is crucial to understand that the prescription of a general time limit by this court within which the ordinary exercise of power by the governor under Article 200 must take place is not the same thing as amending the text of the Constitution to read in a time limit, thereby fundamentally changing the procedure and mechanism of Article 200. This is because reading such a time limit into the provision neither militates against the underlying object of the said provision, nor does it alter the procedure that is envisaged therein. On the contrary, it only reinforces the sense of expediency and urgency that has been time and again emphasized since the adoption of the Constitution. The reason why the prescription of a time limit does not tantamount to an alteration or amendment is because the time limit that is being prescribed by cannot be understood to be a hanging sword on the governor, whereby even an unavoidable non-compliance would automatically ensure the consequences of assent. The nature of such prescription is quite different, which may be better explained through the concept of judicial review. Para 238. For the exercise of judicial review, the existence of a certain set of definitive standards against which the courts can embark upon the scrutiny is quintessential. Without these standards, the power of judicial review could be said to be ineffective in certain contexts, which shall be elucidated upon in the later parts of the judgment. The doctrine of stare decisis is not just concerned with ensuring that decisions of higher courts or of larger benches are duly adhered to and questions of law already settled and put to quietus by higher judicial authorities are not disturbed. The idea is also to infuse a sense of judicial comity within the intertwined hierarchical codes in the manner of their functioning. Additionally, one of the core precepts of stare decisis is that not only the decisions but the very decision making process of the courts are predicated upon a discernible standard, often coined as judicially manageable standards. We shall discuss this in more detail in the latter parts of the judgment. Para 239. Any time limit in the exercise of powers in terms of Article 200 of the Constitution should not be construed as timelines laid within the edifice of the provision, rather should be understood as timelines that would serve as a lodestar for the purpose of exercise of judicial review by the courts, a benchmark tool to aid and enable the courts in ascertaining if any inaction or malfeasance has occasioned in the exercise of such powers. These times sorry These timelines no doubt demand the earnest adherence by the governor. However, these being nothing more than tools upon which scrutiny by judicial review is to be premised, remain as prescriptions within the realm of judicial review alone and do not transgress into the legislative bounds or amount to alteration of the text or authority of Article 200 of the Constitution. The reason why these time limits do not immolate the very fabric of Article 200 is because the said provision, even with the infusion of this time limit, still remains markedly different from its counterpart provisions where such time limits are legislatively prescribed. For instance, Article 75 of the Constitution of the sorry, Article 75 of the Constitution of the Islamic Republic of Pakistan or Article 1, Section 7 of the US Constitution, where if no decision is taken within the stipulated time limit by the President, then the bills are deemed to have been assented to. Paragraph 240. Sorry. Thus, it is important to take note of this very fine but pertinent distinction that the prescription of a time limit by this court into Article 200 of the Constitution does not fundamentally change the procedure which has been envisaged. While the reading in of a time limit under Article 200 would have meant that there would be deemed assent upon failure of the governor to comply with the said timeline, the prescription of a reasonable time period does not introduce any such mechanism or deeming fiction in Article 200. Para 241. What emerges from the above is that the fine but pertinent distinction between the time limits that are expressly prescribed and those that are judicially evolved is only that in the former, the consequence of deemed assent emanates from the provision itself, whereas in the latter, there could be no such consequence except to the extent that the courts judicially reviewing the action or inaction can direct a decision to be taken within a time-bound manner or in exceptional cases like the one at hand deem the assent to have been granted under Article 142 of the Constitution, which we shall again discuss in the later parts of this judgment. Para 242. When prescribing such a time limit for the exercise of power under Article 200, we are guided by the inherent expedient nature of the procedure prescribed thereunder and the well settled legal principle that where no time limit for the exercise of a power is prescribed, it should be exercised within a reasonable period. Para 243. What would be a reasonable period would vary from situation to situation. However, in the present case, taking guidance from the timelines that have been prescribed by the Sarkaria and the Punchi Commission, we have arrived at the view that in the absence of any exceptional circumstances, The governor would be able to exercise his power under the article within the maximum period prescribed by us. Para 244. While the reading in of an absolute time limit would have left the governor with no choice but to comply with it, the prescription of the judicially evolved time limits by us leaves it open for the governor to justify the delay caused by providing reasonable grounds. Delay caused by the governor beyond the prescribed time limits would be justiciable, and the courts, with deference to applicable judicial principles, would be fully competent to ascertain whether the delayed exercise of power by the governor under Article 200 was based on any reasonable grounds or not. Para 245. The prescription of a time limit is with a view to ensure that the governor is not conferred with the power of exercising a pocket veto under the scheme of Article 200 and hinder the lawmaking process in the state without the existence of any reasonable grounds. While the decision in Nambudri quoted Supra does not make the prescription of such a time limit by the court impermissible, the decisions adverted to above vest this court with sufficient power to ensure that the procedure prescribed under Article 200 is followed by the governor in a constitutionally permissible manner and in line with the principles of parliamentary democracy, keeping in mind the nature of the power. Such an approach also ensures that the state governments are not left remediless in case of malicious, arbitrary, or capricious exercise of power by the governor under Article 200. Para 246. We also deem it necessary to prescribe a timeline for the discharge of functions by the governor under Article 200. The Sarkaria and Punchi commissions in their reports adopted this view, keeping in mind the importance of an expeditious decision under Article 200 for the smooth functioning of electoral democracy in the states. An elected government gets the mandate of the people for a limited period of 5 years, within which it is expected to legislate on issues pertaining to the electorate. If the governor, for whatsoever reasons, exhibits reluctance or lethargy in decision making, particularly when it is concerned with the assent to bills, it severely impacts the ability of the government to act upon its mandate and deliver to the people who brought them into power. Any obstacle created by the governor, whether advertently or inadvertently, severely impacts the perception of the elected government in the subsequent elections and thereby also negatively affecting the chances of coming back into power. The problem is further exacerbated when the political party in power in the state is different from the one at the center, and the governor should be more cautious and non partisan in the exercise of his functions in such a scenario. Any deliberate inaction on part of the governor in assenting to bills or reserving them for the consideration of the president thus has to be viewed as a serious threat to the federal polity of the country, and the aggrieved governments cannot be left remediless, desperately waiting for a decision at the hands of the governor. Para 247. This court in state of Punjab quoted Supra held that the constitution terms any inaction on part of the governor as deplorable and that he cannot indefinitely keep the bills passed by the state legislature on a chokehold. The relevant observations read as under. Quote, Para 24, ellipsis, the emphasis. The Constitution evidently contains this provision, bearing in mind the importance which has been attached to the power of legislation, which squarely lies in the domain of the state legislature. The governor cannot be at liberty to keep the bill pending indefinitely without any action whatsoever. End of quote. Emphasis supplied. Para 248. It is not unusual for this court to prescribe time limits for the discharge of certain functions, even in cases where no specific time limit has been prescribed. Recently, in Periyammal, dead through LR's legal representatives and others versus Rajamani and another, etc., reported in 2025 INSC 329, a two-judge bench of this court, of which one of us, J.B. Pardiwala Justice, was a part, directed all the high courts to issue directions to all the district courts to decide pending execution petitions within a period of 6 months without fail. The directions read as follows. Quote, paragraph 75. In view of the aforesaid, we direct all the high courts across the country to call for the necessary information from their respective district judiciary as regards pendency of the execution petitions. Once the data is collected by SLP, C numbers 8490, 8491 and 8492 of 2020, page 77 of 78, each of the high courts shall thereafter proceed to issue an administrative order or circular directing their respective district judiciary to ensure that the execution petitions pending in various courts shall be decided and disposed of within a period of 6 months without fail. Otherwise, the concerned presiding officer would be answerable to the High Court on its administrative side. Once the entire data, along with the figures of pendency and disposal thereafter, is collected by all the high courts, the same shall be forwarded to the registry of this court with individual reports. End of quote. Para 249. We have already discussed that in Kesham, quoted Supra, a three-judge bench of this court fixed an outer time limit of 3 months for the Speaker to decide disqualification petitions under the 10th schedule. The court pertinently observed that the said period was fixed, quote, keeping in mind the fact that ordinarily the life of the Lok Sabha and the Legislative Assembly of the states is 5 years, end of quote. This court has also, in a number of decisions, set down and reiterated that the high courts must pronounce judgments on reserved matters within a period of 6 months. Inaction on part of any constitutional authority being subject to judicial review, it is important that there are reasonably laid down standards of justiciability of such inaction, and the timelines prescribed by us serve that purpose. Even the Constituent Assembly had initially laid down a period of 6 weeks for the President to take action on bills submitted to him under Article 111. However, that was later changed to account for any exceptional circumstance that may arise in the discharge of functions by the President or the Governor. However, the expression 6 months was replaced with as soon as possible, which, though not determinable, envisages an expeditious disposal of bills unless in cases where some impossibility exists. The prescription of timelines bias balances the objective of expediency as well as the desirability of having some flexibility in cases of existence of an impossibility in discharge of functions in an expeditious manner. Flexibility in the discharge of a function cannot be allowed to be stretched to an extent that renders the very object underlying such function odious, resulting into the proverbial snapping of the constitutional machinery. Para 250. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Failure to comply with these timelines would make the inaction of the governors subject to judicial review by the courts. Item 1. In case of either withholding of assent or reservation of the bill for the consideration of the President upon the aid and advice of the State Council of Ministers, the Governor is expected to take such an action forthwith subject to a maximum period of 1 month. In case of withholding of assent contrary to the advice of the State Council of Ministers, the Governor must return the bill together with a message within a maximum period of 3 months. Item 3. In case of reservation of bills for the consideration of the President contrary to the advice of the State Council of Ministers, the Governor shall make such reservation within a maximum period of 3 months. In case of presentation of bill after reconsideration in accordance with the first proviso, the Governor must grant assent forthwith, subject to a maximum period of 1 month. Para 251. Failure to comply with the timelines prescribed above would make the inaction on part of the Governor amenable to judicial review. We shall also deal with the necessity of expeditiously disposing of the references under Article 201 by the President in subsequent parts of this judgment. Section 4. Whether the Governor, in the exercise of his powers under Article 200 of the Constitution, can only act in accordance with the aid and advice tendered to him by the State Council of Ministers. Para 252. Significant time was spent during the course of the arguments on the key issue of the scope of discretion enjoyed by the Governor in exercise of his powers under Article 200 more particularly as regards the reservation of bills for the consideration of the President. Para 253. Mr. Rohadgi, learned senior counsel, submitted that the act of the governor amounts to a subversion of the constitution. He further emphatically submitted that indeed amounted to a subversion of the constitution. Para 254. He also submitted that there was no discretion available to the governor under the scheme of Article 200 of the Constitution, and the only exception to the same was provided in the second proviso to Article 200 itself. In other words, he contended that the governor could only reserve a bill against the advice tendered to him by the Council of Ministers if the bill was of a description as provided in the second proviso. He submitted that in all other cases, the reservation of a bill for the consideration of the President had to take place strictly in accordance with the advice of the Council of Ministers. Para 255. This argument was also endorsed by Dr. Singhvi, who added that the observations made in B.K. Pavitra quoted supra as regards the discretion of the governor under Article 200 of the Constitution have to be understood in the context of the reservation taking place on the aid and advice of the Council of Ministers. Para 256. Mr. Dwivedi, placing reliance on the deletion of the expression in his discretion from both the substantive part of Article 200 as well as the first proviso by the Constituent Assembly, proposed an even stricter interpretation of Article 200. He argued that the deletion of the expression in his discretion indicated that the intention of the framers of the Constitution was crystal clear that the governor should have no semblance of discretion while exercising his powers under Article 200, and he should act in accordance with the advice rendered by the Council of Ministers. He further submitted that it is not just reservation of the bills for the consideration of the President, but the grant of assent as well as the decision to send the bill back to the state legislature, together with a message upon the withholding of assent, which must be taken strictly in accordance with the advice of the Council of Ministers. Para 257. The Attorney General, per contra, argued that while exercising his powers under Article 200, the governor is discharging an important constitutional obligation, and even if he does not exercise individual discretion, he may still act against the aid and advice of the Council of Ministers if he is so required to in the discharge of his constitutional duties. Para 258. An answer to the aforesaid question cannot be arrived at without first answering the following sub-questions. Item A. How has the office of the governor been envisaged by the constitutional scheme? In what manner does he play a dual role in the federal polity of the country? Item B. Whether the governor enjoys a certain degree of discretion in discharge of his duties under the Constitution. What is the source of such discretion? Item C. Does the deletion of the expression in his discretion from Article 175 of the draft Constitution imply that the governor has no discretion available in the exercise of his powers under Article 200? Item A. The Office of the Governor. Para 259. With the enactment of the Government of India Act 1858, the administration of India transitioned from the East India Company to the British Crown, bringing about a new administrative framework wherein the governor, as an agent of the Crown, operated under the general supervision of the Governor General. While this structure prevailed, the Montagu-Chelmsford reforms of 1919, which culminated into the Government of India Act 1919, marked the early stirrings of responsible government, albeit in a nascent form. Despite this shift, the governor remained central to the provincial administration, continuing to wield significant authority. The Government of India Act 9. Paragraph 260. The Government of India Act 1935 ushered in the era of provincial autonomy and formally required the governor to act on the advice of the ministers who are accountable to the provincial legislature by abolishing the system of diarchy at the provincial level while introducing it at the central level. However, the Act also conferred upon the governor certain special responsibilities such as maintaining peace and tranquility within the province and safeguarding minority interests. These responsibilities necessitated the exercise of discretion by the governor in specific matters. Further, the autonomy of the governor in such cases remains subject to the general superintendence and control of the governor general, ensuring oversight over the exercise of his individual judgment. Para 261. The Declaration of Independence brought about a fundamental transformation in the role of the governor. Until the Constitution came into effect, the provisions of the Government of India Act 1935, as modified by the India Provisional Constitution Order 1947, for short, the Adaptation Order, governed the administration of the country. Significantly, the Adaptation Order omitted the expressions in his discretion, acting in his discretion, and exercising in his individual judgment from the Act, signaling a departure from the colonial framework. Para 262. One of the key decisions that the framers of the Constitution had to take was to decide the mode of selection of the governor, whether he should be elected by way of a direct election or selected from a panel of names suggested by the state legislature or nominated by the president. While in the early days the Constituent Assembly leaned towards having an elected governor, as the framing of the Constitution neared its conclusion, there was increasing support in favor of having a governor nominated by the president. Jawaharlal Nehru attributed this shift of opinion to the bitter experience of partition, which, according to him, opened the eyes of the Constituent Assembly to the dangers of separatism and the need for having a political structure which focused more on the character of the nation as a union of states rather than a federation. Item B. Constituent Assembly debates on the mode of selection of the governor. Para 263. The speeches made by some of the members of the Constituent Assembly, Article 155 of the Constitution, broadly encapsulate the ideas which were debated and rejected before nomination was selected as the mode of appointment for the governor. Para 264. Speaking in favor of appointment of governors by presidential nomination, Sri H.V. Kamath was of the opinion that the concept of an elected governor would undermine the structure of the country as a union of states, since a governor elected directly by the people on the basis of adult suffrage would place more emphasis on India being a federation. However, according to him, the emphasis today is more upon the union pattern of our state than upon its federal aspect. He believed that an elected governor, being a partisan figure, would inevitably clash with his chief minister, thereby disrupting the functioning of a cabinet style government. According to him, the role of a constitutional head should be impartial and symbolic, and the nomination system was better suited to uphold these principles. He further elaborated on the potential tussle that would ensue between an elected governor and the chief minister of the state as follows. Quote, ellipsis. If the governor were to be elected by the direct vote of all voters in a province, he is very likely to be a party man with strong views of his own, and considering that he will be elected by the whole province, by the entire adult population of the province, he will think that he is a far superior man and a far more powerful man than the chief minister or the premier of the state, who will be returned from one constituency only, but because he happens to be the leader of the majority party, he will be nominated premier by the governor. There will be two conflicting authorities within the state. One is the premier, whom under this constitution, which we are considering today, we have invested with executive authority so far as the state is concerned, and the other is the governor, who, though the constitution does not confer on him very substantial powers and functions, will arrogate much to himself, because he will say that, quote, I have been elected by the people of the whole province, and as such I am persona gratia with the people and not the chief minister, end of quote. Therefore, there will be in the administration of the province at every turn, if not at every turn, then very often, points of conflicts or friction between the elected governor and the elected chief minister. Therefore, I think we have done very wisely in deleting or in doing away with the system of election for the provincial governor. End of quote. Para 265. Sri Hukam Singh, opting for the middle path, acknowledged the difficulties inherent in both pure election and pure nomination for the purpose of appointment of governors. While agreeing with Sri H.V. Kamath on the drawbacks of an elected governor, such as the potential for conflict with the chief minister and the high costs involved in conducting elections, he proposed a balanced alternative, suggesting that a panel of candidates be nominated by the state legislature and a governor be chosen from the same panel. This method, while allowing for some discretion, would also ensure public accountability since the merits of those individuals who had been recommended in the panel would be publicly available, and if the right person was not chosen, then the selection would also be criticized publicly. In his view, this approach would reduce favoritism, enhance transparency, and provide a safeguard against the abuse of power, striking a middle ground between the extremes of election and direct nomination. Para 266. Shri Rohini Kumar Chowdhury opposed the nomination of governors, cautioning that a center appointed governor belonging to a different political party than the provincial government could lead to discord and undermine provincial autonomy. The friction that would result from adopting a system wherein governors are elected would also exist, according to him, when a governor is nominated, since the nominee of the president would not work in harmonious tandem with the ministry of the state, which belongs to a different political party than the one which enjoys power at the center. He argued that electing governors would ensure that they are more attuned to the needs of all communities, including marginalized groups like tribal populations in states where the governor would have an even more important role to play. He criticized the reliance on British precedents and advocated for a more democratic process, such as election or selection from a panel, to reflect the will of the people and to also safeguard provincial interests. Para 267, Sri Alladi Krishnaswamy Iyer was of the view that since the governor is merely a constitutional head of the province and the real executive power had been vested in a ministry responsible to the lower house of the different states, it seemed rather unnecessary under such circumstances to adopt the method of election based on universal suffrage for the appointment of the governors. The nomination of governors by the president would, in his opinion, mitigate constitutional conflicts and foster harmonious relations between the governor and the provincial cabinet. He argued that an elected governor deriving authority from universal suffrage might assert dominance over the cabinet, leading to significant constitutional risks. He specifically remarked that, quote, in the normal working of the government, also, there is a danger of a clash between the minister and the governor, whereas the whole basis of the constitutional structure we are erecting depends upon the harmony between the legislature and the executive, and between the executive and the formal head of the government. End of quote. Drawing inspiration from the Canadian model, he suggested that the president's appointment of governors, guided by the advice of the provincial cabinet, would ensure stability and sound governance. Furthermore, according to him, quote, nowhere does the system of election of the governor exist where the institution of responsible government is the main feature of the constitution. End of quote. He believed that this system would better serve the interests of the provinces and the nation as a whole. Para 268. It was his belief that while the method of nomination was the most appropriate one, a convention of appointing governors in consultation with the state government would grow. This, when read with the other discussions which took place in the Constituent Assembly, indicate that the framers of the Constitution reposed trust that the governor would not be a cipher of the central government, would be a person above party politics, and would not attempt to override the state government with his actions. He also supported the idea of having nominated governors on the ground that the intervention of the governor would be required only in extraordinary situations, and an elected governor may come in conflict with the provincial cabinet by trying to override their decisions. His words are reproduced below, quote, I see no objection to the appointment of the governor being left to the President of the Union, who has necessarily to act on the advice of the Prime Minister and his cabinet. A convention of consulting the provincial cabinet might easily grow up. Such a convention, as the House is aware, has grown up in the appointment of governors in Canada. In Australia too, though under a different constitution, a similar convention has grown up and the governor of a state is appointed on the advice of the provincial cabinet. Ellipsis. There is another aspect also which the House might take into consideration. In our constitution, we must try every method by which harmony could be secured between the center and the provinces. Emphasis. If you have a person who is not elected by the province or the state, but you have a person appointed by the President of the Union with the consent, I take it, of the provincial cabinet, you will add a close link between the center and the provinces, and a clash between the provinces and the center will be avoided, which will otherwise occasionally result. End of emphasis. Then there is another point. It is said that the governor may occasionally have to use his extraordinary powers. This point is more in favor of nomination rather than in favor of election. If the person who is elected on the basis of universal suffrage is to come into clash with the provincial cabinet, and if he is to set himself above the provincial cabinet, there will be a greater constitutional danger. Emphasis. Even if circumstances arise when intervention by the governor is necessary, it will be only on extraordinary occasions. End of emphasis. Even for that intervention, a person who is nominated or appointed by the president with the concurrence of the provincial cabinet is likely to take far greater care than a person who is elected by the people. On the whole, in the interest of harmony, in the interests of good working, in the interest of sounder relations between the provincial cabinet and the governor, it will be much better if we adopt the Canadian model and emphasis have the governors appointed by the president with the convention growing up that the cabinet at the center would also be guided by the advice of the provincial cabinet. End of quote, end of emphasis, emphasis supplied. Para 269. Shri P.S. Deshmukh was of the opinion that there Para 269. Para 269. Shri P.S. Deshmukh was of the opinion that there exist a few fundamental considerations which have to be kept in mind while discussing the appointment of the governor. The first of these fundamental considerations was that, quote, if we decide that the governor should be elected by the province on the basis of adult franchise, then it follows logically that he should be a real executive authority. On the other hand, if you want him to be mere figurehead, if you want him to have exactly the same position as he has today under the 1935 Act, and which is exactly the position which is assigned to him under the draft constitution, you cannot but have him appointed by the president. End of quote. In light of this, he buttressed his view that governors must be nominated and not elected. Regarding the concern that adopting a system of nominating the governor would give undue power to the prime minister and the president, he opined that the prime minister would also be a popular prime minister and that he can only be there as long as he has the support of the parliament elected by the people at large. Therefore, his view was that we must not hesitate in giving powers of patronage to the prime minister or the president. He also expressed concerns about the potential discord between an elected governor and the chief minister or premier, which could disrupt governance. Apart from the very real possibility of conflicts between the elected governor and the chief minister, which necessitated appointment via nomination, he argued, on the other hand, that if there was no conflict and there was perfect agreement or collusion between the governor and the chief minister, they could agree in defying the center altogether, and that would put the center in a precarious position where they would be completely blocked out from the states. Therefore, he remarked that, quote, but apart from the conflict, if there is no conflict and there is perfect agreement, if these two gentlemen set the center at naught, what will be the position? End of quote. Hence, in his opinion, the appointment of governors by the president would maintain a balance of power and ensure some degree of central influence over provincial matters. He further suggested that governors should serve at the pleasure of the president, thereby eliminating the need for impeachment provisions and also reinforcing the oversight of the center. Para 270. Sri Hridaynath Kunzru highlighted the potential for friction between governors and their cabinets, specifically with reference to Article 175 of the draft constitution, which has now been adopted as Article 200. By drawing comparisons to the Canadian model, he argued that empowering the president to disallow provincial bills directly by overriding the assent of the governor within a certain prescribed period of time from the date of such assent rather than relying on the governors as intermediaries who refer the bill for the consideration of the president would centralize responsibility with the central executive and reduce conflicts at the provincial level. In his view, this approach would align with the principles of responsible government and ensure smoother governance. Para 271. Pandit Jawaharlal Nehru emphasized the need for, sorry, Para 271. Pandit Jawaharlal Nehru emphasized the need to foster unity and avoid separatist tendencies within the nation. He believed that an elected governor could exacerbate provincial divisions and weaken ties with the center. In his opinion, nevertheless, a certain convention, quote, nevertheless, a certain convention and practice helps or hinders the growth of separatist tendencies. I feel that if we have an elected governor, that would to some extent encourage that separatist provincial tendency more than otherwise. There will be far fewer common links with the center. End of quote. He argued that duplicating the electoral process for the office of governor would be unnecessary and counterproductive, leading to conflicts, wastage of resources, and disruptive tendencies. Supporting the nomination of governors, he asserted that this approach would align with the parliamentary system of democracy and strengthen the relationship between the provinces and the center. Part C. Constituent Assembly debates on the exercise of discretion by the governor. Para 272. The other key question which fell for the consideration of the Constituent Assembly was whether any discretion would be made available to the governor as the constitutional head of the state. Article 163, Clause 1 of the Constitution, which describes the nature of such discretionary powers, reads as follows. Quote, Clause 1. There shall be a council of ministers with the chief minister at the head to aid and advise the governor in the exercise of his functions, except insofar as he is by or under this constitution required to exercise his functions or any of them in his discretion. End of quote. Para 273. To understand the true import and the scope of this discretion which exists with the governor, it would be apposite for us to look into the Constituent Assembly debates pertaining to this article in some detail. Article 163, which provides for the Council of Ministers to aid and advise the governor, was earlier numbered as Article 143 under the draft constitution. Two amendments were sought to be moved to draft Article 143 on the 1st of July 1949. However, those did not gain the approval of the Constituent Assembly, and the original version of draft Article 143 came to be later adopted as Article 163 as we see it. Para 274. Of the two amendments, one of which was moved by Sri H.V. Kamath, sought to delete the expression, quote, except insofar as he is by or under this constitution required to exercise his functions or any of them in his discretion. End of quote. Sri H.V. Kamath was of the opinion that the draft article had been blindly copied from the Government of India Act 1935 without any matured consideration. He further remarked that, quote, there is no strong or valid reason for giving the governor more authority either in his discretion or otherwise vis-a-vis his ministers than has been given to the president in relation to his ministers. End of quote. Investing such wide discretionary powers on the governor was all the more problematic, according to him, since governors are nominated to their positions and not elected. No departure from the principles of a constitutional government must be favored except for reasons of emergency, and therefore he advocated for these discretionary powers to be done away with. Para 275. However, Sri T.T. Krishnamachari pointed out that there existed specific provisions under the draft constitution wherein the governor was in fact empowered to act in his discretion irrespective of the advice tendered by his council of ministers. Therefore, according to him, there were two ways of drafting which would capture the aforesaid underlying idea. One would be to make a mention of this exception under draft Article 143 itself and enumerate the specific scenarios where the governor would be able to exercise his discretion in the subsequent relevant articles, or two would be to leave out any mention of this discretionary power under draft Article 143 and only state it in the appropriate articles that will follow. In the case of draft Article 143, according to him, it was only that the former method had been followed. Therefore, the general proposition or the default rule would be that, quote, the governor has normally to act on the advice of his ministers except insofar as the exercise of his discretions covered by those articles in the constitution in which he is specifically empowered to act in his discretion. End of quote. Para 276. As an illustration, Sri T.T. Krishnamachari referred to draft Article 188, which related to the proclamation of emergency in states by the governor under his discretion. It was his opinion that if such a discretionary power can be given under draft Article 188, there is no harm in the mention of discretion under draft Article 143 either. He understood the scheme of the draft constitution to mean that unless there is a specific mention of discretion under any subsequent article, the discretionary power mentioned under draft Article 143 cannot at all be exercised. Paragraph 277. Sri Brajeshwar Prasad was not in favor of the amendment that was put forth, since he was of the opinion that the governor should be vested not only with the power to act in his discretion, but also with the power to act in his individual judgment. He was of the view that there was a dearth of leadership in the provinces wherein competent men were not available, and unless the governor is vested with large powers, it would be difficult to effect any improvement in the provincial administration. He went to the extent of saying that though such a procedure may be considered as undemocratic, it would be in the interest of the country. He remarked that I cannot allow democracy to jeopardize the vital interests of the country. Ellipsis. The masses who ought to be the rulers of this land are downtrodden and exploited in all ways. Under these circumstances, there is no way left open but for the government of India to take the provincial administrations in its own hands. End of quote. In his opinion, federalism could not succeed in a country which was passing through a transitory period, and therefore he subscribed to the view that power must be vested at the center, and as a natural corollary, the governor must be able to act in his discretion. Para 278. Sri Mahavir Tyagi was also in agreement with the view that the governor must be granted discretion. In his opinion, the state must be kept linked together with the center, and the governor would be the agent who guards the central policy in the provinces or states. There would be certain subject matters which affect the whole body politic, and the provinces or states cannot be left free of the policy at the center. Since the policy which is evoked in the center must be followed by all the states, and if the governors were to be in the hands of the provincial ministers, then there will be various policies in various provinces, and ministers of various types having different party labels and programs would push their own agenda. Therefore, it was his view that the governor, being the agency of the center, would be the only guarantee to integrate the various provinces or states. End of quote. According to him, this is why the governor's discretionary powers should not be interfered with. He went on to remark that democratic trends are like a wild beast and that it goes by the whims and fancies of the parties and the masses. There must be some machinery which would keep this wild beast under control. It is in such a reality that the governor, exercising his discretion, acts as a guardian of the central policy on one side and the constitution on the other. Para 279. Sri B.M. Gupta was of the view that if certain powers had to be given to the governor, our endeavor must be to restrict them as far as possible so that the governor's position as a constitutional head may be maintained. Para 280. Sri Alladi Krishnaswamy Iyer echoed the stance taken by Sri T.T. Krishnamachari. He stated that in the first place, a general principle under Article 143 is laid down, namely the principle of ministerial responsibility, that the governor in the various spheres of executive activity should normally act on the advice of his ministers. Then the article goes on to carve out an exception as regards the matters under which the governor is required to exercise certain functions under his own discretion. Therefore, it was his conclusion that as long as there are articles under the Constitution which enable the governor to act in his discretion, the draft Article 143 as it was framed was perfectly in order. In certain circumstances, this exercise of discretion may be to override the cabinet or to refer to the president. If later on the Constituent Assembly were to arrive at the constitutional conclusion that those subsequent articles which enable the governor to act in his discretion in specific cases must be deleted, it would be open to revise draft Article 143. But as long as there are articles occurring later in the Constitution which permit the governor to act in his discretion and not on ministerial responsibility, the present draft Article 143 was drafted rightly. Para 281. The only other question, in his opinion, was to see whether the Constituent Assembly had to first make a provision under draft Article 143 that the governor shall mandatorily act on ministerial responsibility and then go on to provide, quote, notwithstanding anything contained in Article 143, ellipsis, he can do this, or that, notwithstanding anything contained in Article 143, he can act in his discretion in the subsequent relevant articles. However, he favored the method of drafting that had already been adopted. That is, to provide in draft Article 143 itself that the governor shall always act on ministerial responsibility, excepting in particular or specific cases where he is empowered to act in his discretion. If, of course, the Constituent Assembly came to the conclusion that in no case the governor shall act in his discretion and that he shall in every case act only on ministerial responsibility, then there will be a consequential change to this. Para 282. Thakur Das Bhargava adopted the notion that the governor, quote, shall be a guide, philosopher, and friend of the ministry as well as the people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions, and some will be such as will be expressly conferred by this constitution. End of quote. The governor's role would transcend party politics and he would look at the minister and the state government from a detached standpoint. He would also be able to influence the ministers and members of the legislature in such a manner that the administration would run smoothly. In such a circumstance, to say that he is merely a dummy, an automaton, or a dignitary without powers would be gravely wrong. According to his conception of a constitutional governor, the governor would have to accept the advice of his ministers in many matters, but there may also exist many other matters in which such an advice will either be unavailable or wherein he will not be bound to accept that advice. Another illustration, according to him, of when the governor would act in his discretion would be under draft Article 147 or Article 167 as it stands today, where the governor can exercise his power of calling for certain information from the chief minister. Under this article, the governor is competent to ask the chief minister to place any matter before the council of ministers which only one minister might have decided. When he calls for such information, he will be acting in the exercise of his discretion and may call for any kind of information with a view to control and restrain the ministry from undertaking irresponsible acts. Therefore, he remarked that, quote, in my opinion, taking the governor as he is conceived to be under the constitution, he will exercise very important functions and therefore it is very necessary to retain the words relating to his discretion in Article 143. Para 283. Sri Rohini Kumar Chaudhary put forth the alternative view that it is always better to be governed by the will of the people than to be governed by the will of a single person who would act in his discretion. He remarked that if this governor is given the power to act in his discretion, there is no power on earth to prevent him from doing so. He can be a veritable King Stark. End of quote. Furthermore, the draft Article 143 itself states that wherever the governor thinks that he is acting in his discretion, he cannot be questioned. According to him, in this day and age, we must not countenance such a state of affairs. Paragraph 284. While concluding the debate on draft Article 143, Dr. B.R. Ambedkar elaborated that the main and crucial question under this draft article was whether the governor must have certain discretionary powers or not. During the course of the debate, it was pointed out that the retention of discretionary powers in the governor was contrary to responsible government in the states or provinces. It was also stated that the same mimicked the Government of India Act 1935, which was largely assailed as being undemocratic. However, Dr. B.R. Ambedkar was of the undoubted view that, quote, the retention in or the vesting the governor with certain discretionary powers is in no sense contrary to or in no sense a negation of responsible government. End of quote. He cited section 55 of the Canadian Constitution, which read as follows. Quote, Section 55. Where a bill passed by the House of Parliament is presented to the Governor General for the Queen's assent, he shall, according to his discretion and subject to the provisions of this Act, either assent thereto in the Queen's name or withhold the Queen's assent or reserve the bill for the signification of the Queen's pleasure. End of quote. Para 285. He conveyed that the Canadians and the Australians had not found it necessary to delete these provisions even in this day and age, and that they were quite satisfied with its retention. This, he argued, was demonstrative of the fact that the grant of such a discretion to the governor is fully compatible with a responsible government. If they had felt otherwise, they had the fullest right to abrogate this provision and would have done so. Therefore, the existence of a provision vesting a certain amount of discretion in the governor cannot be questioned. Furthermore, the draft article reads that, quote, except insofar as he is by or under this constitution, and not that except wherever he thinks that he should exercise this power of discretion against the wishes or against the advice of the ministers. Therefore, the clause is very limited in nature and would have to be read in conjunction with such other articles which specifically reserve the discretionary power for the governor. It must not be construed as a general clause which gives the governor the power to disregard the advice of his ministers in any matter in which he finds that he could disregard their opinion. Para 286. Now, moving on to how an article providing for a certain amount of discretionary powers to the governor is to be framed, Dr. B.R. Ambedkar declared that there are several ways in which the same can be done. One way could be to omit the words from the draft Article 143 and to add to draft Articles 175, presently Article 200, 188, or such other provisions, an express mention which vests the governor with discretionary power. Those articles would then mention that notwithstanding draft Article 143, the governor would have a certain discretionary power. Another way would be to state in draft Article 143 itself that, except as provided in draft Articles 175, 188, etc., the governor shall act in accordance with the aid and advice of the Council of Ministers with the Chief Minister at the head. However, irrespective of what method of drafting is adopted, the essential point that would remain is that the governor's discretionary power must be acknowledged in some form. Para 287. Dr. B.R. Ambedkar was open and quite willing to concede to the position of those members who were of the view that the last portion of Clause 1 of Draft Article 143 must be amended to mention the specific articles under which the governor shall exercise discretion if at that stage of the Constituent Assembly debates the provisions intended for such vesting were already determined. The difficulty was that the Constituent Assembly had not yet arrived at a stage where they could discuss draft Articles 175 or 188, nor had they exhausted all the possibilities of other provisions being made which vested the governor with the discretionary power. If all those possibilities were already known, draft Article 143 could have been amended and those specific articles could have been mentioned or listed out. Therefore, Dr. B.R. Ambedkar was firmly of the view that no wrong could be done if the words as they stood in the draft article were retained. Para 288. While acknowledging that there exists a material difference between draft Article 61, Clause 1, which is Article 74, Clause 1 as it stands today, relating to the executive functions of the President vis-à-vis his ministers, and the draft Article 143, Dr. B.R. Ambedkar elucidated that it was not the intention of the drafters to vest any discretionary power upon the President. It is because the provincial governments are required to work in subordination to the central government, and in order to ensure that they do act in such subordination, the governor would reserve certain matters, thereby giving the president an opportunity to see that they are broadly in compliance with the policy of the central government. Through this mechanism, the president would be able to ensure that the rules under which the provincial governments are supposed to act according to the constitution are observed. Therefore, the vesting of discretionary powers in the post of the governor was considered crucial to enable this administrative dialogue between the center and the provinces. Para 289. What follows from a study of the Constituent Assembly debates concerning the appointment of the governor and the scope of his discretionary powers is that the governor plays a very crucial role in the political structure of the country. He is the bridge between the governments at the central and state level, the proverbial buckle which ties the states with the center. The Punchi Commission report also acknowledged this dual role of the governor, one as the custodian of the constitution in the states and a representative of the union, and the other as the constitutional head of the state and a friend, philosopher, and guide of the state government as well as the people. The position of the governor and how it differs from that of the president were discussed by Dr. B.R. Ambedkar as we have elaborated in the preceding paragraphs. This difference was also taken note of by Krishna Iyer Justice in his opinion in Samsher Singh quoted Supra, as we will discuss subsequently. We are of the firm view that this unique position of the governor must be kept in mind whenever we set out to interpret any provision of the constitution pertaining to any gubernatorial powers or functions. It is not terminologies like federal, quasi-federal, or unitary which should guide our interpretation of the Constitution. In turn, the words and ideas of the wise artisans who carefully weaved the fabric of the Constitution with threads borrowed from across the world after dyeing them in colors uniquely Indian, that we should look towards when in doubt about the fundamental ideas of Constitution. The framers of the Constitution were cognizant of the fact that vesting the center with excessive powers would not be healthy for the country's polity. In this regard, we may refer to the observations made by the Sarkaria Commission. Quote, there is considerable truth in the saying that undue centralization leads to blood pressure at the center and anemia at the periphery. The inevitable result is morbidity and inefficiency. Indeed, centralization does not solve but aggravates the problems of the people. End of quote. Therefore, the curtailing of the powers of the governor under the Constitution, as distinguished from the Government of India Act 1935, was done keeping in mind that the centre does not arrogate all powers to itself by utilizing the governor as an intermediary of the centre at the state. Para 290. Arijit Prasayat, Justice, in his dissenting opinion in the decision of this court in Rameshwar Prasad, quoted Supra, observed thus on the role of the governor. Quote, Para 270. As noted above, the governor occupies a very important and significant post in the democratic setup. When his credibility is at stake on the basis of allegations that he was not performing his constitutional obligations or functions in the correct way, it is a sad reflection on the person chosen to be the executive head of a particular state. Emphasis. A person appointed as a governor should add glory to the post and not be a symbolic figure oblivious of the duties and functions which he has and is expected to carry out. It is interesting to note that the allegations of favoritism and malafites are hurled by other parties at the governors who belonged or belong to the ruling party at the center, and if the governor at any point of time was a functionary of the ruling party. The position does not change when another party comes to rule at the center. It appears to be a matter of convenience for different political parties to allege malefices. This unfortunate situation could have been and can be avoided by acting on the recommendations of the Sarkaria Commission and the Committee of the National Commission to review the working of the Constitution in the matter of appointment of governors. This does not appear to be convenient for the parties because they want to take advantage of the situation at a particular time and cry foul when the situation does not seem favorable to them. End of emphasis. This is a sad reflection on the morals of the political parties who do not lose the opportunity of politicizing the post of the governor. Sooner the remedial measures are taken would be better for democracy. Para 271. Emphasis. It is not deficiency in the constitution which is responsible for the situation. It is clearly attributable to the people who elect or seek appoint the governors on considerations other than merit. It is a disturbing feature, and if media reports are to be believed, Raj Bhavans are increasingly turning into extensions of party offices, and the governors are behaving like party functionaries of a particular party. This is not healthy for democracy. Para 272. The key actor in the center-state relations is the governor, who is a bridge between the union and the state. The founding fathers deliberately avoided election to the office of the governor, as is in vogue in the USA, to insulate the office from linguistic chauvinism. The president has been empowered to appoint him as executive head of the state under Article 155 in Part 6, Chapter 2. The executive power of the state is vested in him by Article 154 and exercised by him with the aid and advice of the Council of Ministers, the Chief Minister as its head. Under Article 159, the governor shall discharge his functions in accordance with the oath to protect and defend the Constitution and the law. The office of the governor, therefore, is intended to ensure protection and sustenance of the constitutional process of the working of the Constitution by the elected executive and giving him an umpire's role. End of emphasis. When a Gandhian economist member of the Constituent Assembly wrote a letter to Gandhiji of his plea for abolition of the office of the governor, Gandhiji wrote to him for its retention. Emphasis. Thus, the governor had been given a very useful and necessary place in the scheme of the team. He would be an arbiter when there was a constitutional deadlock in the state, and he would be able to play an impartial role. There would be administrative mechanism through which the constitutional crisis would be resolved in the state. The governor thus should play an important role. In his dual undivided capacity as head of the state, he should impartially assist the president. As a constitutional head of the state government, in times of constitutional crisis, he should bring about sobriety. The link is apparent when we find that Article 356 would be put into operation normally based on the governor's report. He should truthfully and with high degree of constitutional responsibility in terms of his oath inform the president that a situation has arisen in which the constitutional machinery in the state has failed and the government of the state cannot be carried on in accordance with the provisions of the constitution with necessary detailed factual foundation. End of emphasis. Emphasis applied. Para 291. A constitution bench of this court in PP Singhal versus Union of India reported in 2010 6 SCC 331 observed that the governor is neither an employee of the union nor the agent of the party in power. The relevant observations are extracted below. Quote 40. It is thus evident that a governor has a dual role. The first is that of a constitutional head of the state, bound by the advice of his council of ministers. The second is to function as a vital link between the union government and the state government. In certain special or emergent situations, he may also act as a special representative of the union government. Emphasis. He is required to discharge the functions related to his different roles harmoniously, assessing the scope and ambit of each role properly. He is not an employee of the union government, nor the agent of the party in power, nor required to act under the dictates of political parties. End of emphasis. There may be occasions when he may have to be an impartial or neutral umpire where the views of the union government and the state governments are in conflict. His peculiar position arises from the fact that the Indian constitution is quasi federal in character. End of quote, emphasis applied. Para 292. The question of whether the governor is bound to act on the aid and advice of the Council of Ministers in all circumstances fell for the consideration of this court in Samsher Singh's quoted supra. Speaking for the majority, A. N. Ray's Chief Justice observed as follows. Quote 20, para 20, emphasis. Articles where the expression acts in his discretion is used in relation to the powers and functions of the governor are those which speak of special responsibilities of the governor. These articles are 371A, Clause 1, Subclause B, 371A, Clause 1, Subclause D, 371A, Clause 2, Subclause B, and 371A, Clause 2, Subclause F. There are two paragraphs in the sixth schedule, namely Article 9, Clause 2 and Article 18, Clause 3, where the words in his discretion are used in relation to certain powers of the governor. Para 9, Clause 2 is in relation to determination of amount of royalties payable by licensees or lessees prospecting for or extracting minerals to the district council. Paragraph 18, Clause 3 has been omitted with effect from January 21, 1972. Para 21. The provisions contained in Article 371A, Clause 1, Subclause B speak of the special responsibility of the Governor of Nagaland with respect to law and order in the state of Nagaland and exercise of his individual judgment as to the action to be taken. The proviso states that the decision of the Governor in his discretion shall be final and it shall not be called in question. Paragraph 22. Article 371A, Clause 1, Subclause D states that the Governor shall, in his discretion, make rules providing for the composition of the regional council for the Tuensang district. Para 23, Article 371A, Clause 2, Subclause B states that for periods mentioned there, the Governor shall, in his discretion, arrange for an equitable allocation of certain funds between the Tuensang district and the rest of the state. Para 24, Article 371A, Clause 2, Subclause F states that the final decision on all matters relating to the Tuensang district shall be made by the Governor in his discretion. Ellipsis. Para 28, emphasis. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his functions in his discretion. Ellipsis. Para 54, emphasis. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239 Clause 2 states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of the discretion of the governor are paragraphs 9, clause 2 and 18, clause 3 of the 6th schedule and articles 371A, clause 1, subclause B, 371A, clause 1, subclause D, and 371A, clause 2, subclause B, and 371A, clause 2, subclause F. The discretion conferred on the governor means that as the constitutional or formal head of the state, the power is vested in him. In this connection, reference may be made to Article 356, which states that the governor can send a report to the president that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution. Again, Article 200 requires the governor to reserve for consideration any bill which, in his opinion, if it became law, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fill under the Constitution. Para 55, emphasis. In making a report under Article 356, the governor will be justified in exercising his discretion even against the aid and advice of his Council of Ministers. The reason is that the failure of the constitutional machinery may be because of the conduct of the Council of Ministers. This discretionary power is given to the governor to enable him to report to the president who, however, must act on the advice of his Council of Ministers in all matters. In this context, Article 163, Clause 2 is explicable as that the decision of the governor in his discretion shall be final and the validity shall not be called in question. The action taken by the president on such a report is a different matter. The president acts on the advice of his council of ministers. In all other matters where the governor acts in his discretion, he will act in harmony with his council of ministers. The constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of the council of ministers. Para 56. Emphasis. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such courses which are not detrimental to the state. End of quote. Emphasis supplied. Para 293. A reading of the observations reproduced above indicates that the court identified that the governor was required to act on his discretion when performing his functions inter alia under Articles 356 and 200 of the Constitution respectively. However, it is pertinent to note that under Article 200, only the reservation of bells falling under the second proviso was observed by the court to be an exercise which must be undertaken by the governor independent of the advice of the Council of Ministers. Para 296. Furthermore, this court laid down a general rule that the governor, in the cabinet form of government envisaged by the Constitution, acts as a constitutional head, performing all his functions and exercising all his powers on the aid and advice of the Council of Ministers, except in a limited area. This limited area of discretion too is provided by the Constitution under the specific provisions wherein such exercise of discretion is permissible. The court gave certain illustrative examples where the expression acts in his discretion was used and observed that such provisions indicated that a special responsibility on the governor has been entrusted upon by the Constitution. Para 295. It is pertinent to observe the observations made by the court in paragraphs 54, 55 and 56 of Shamsher Singh quoted supra, which are reproduced above. In paragraph 54, while giving illustrations of the provisions where the governor is expressly required by the Constitution to act in his discretion, the court made reference to Articles 356 and 200 respectively. In the context of Article 200, the court observed that the limited area where express discretion has been conferred upon the governor falls under the second proviso. Thereafter, in paragraph 55, the court elaborated upon the exercise of discretion by the governor under Article 356. In paragraph 56, the court elaborated upon the exercise of discretion under Article 200 and observed that Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. It is important to read the observations made in paragraph 56 along with paragraph 54 of the judgment. A conjoint reading of these two paragraphs, it becomes clear without a cavil of doubt that the second proviso to Article 200 is an instance under the Constitution where the governor has been conferred with the power to act in his discretion and even against the advice of the Council of Ministers. However, the logical sequitur to this is that under Article 200, there is no scope for the governor acting in his discretion other than the second proviso. Para 296. Speaking for himself and P.N. Bhagwati Justice, the redoubtable Krishna Iyer Justice in Samsher Singh quoted Supra observed as follows. Quote, paragraph 100. The first broad proposition of the appellants is that the President and the Governor are not just constitutional cousins of the British Queen, but real wielders of power, bestowed on them expressly by the terms of the text, almost next of kin to their American counterparts with similar designations. The issue is so fundamental that its resolution is necessary to know not only who can declare a probationer's fitness, but who can declare a war in national defense or proclaim a backdown of the state constitutional machinery or assent to a bill passed by Parliament. For if under Article 311, the President must be personally satisfied for certain small steps, he must surely be individually convinced regarding the far more momentous spectrum of functions he is called upon to discharge under a big bunch of other provisions. And this reasoning regarding disposal of gubernatorial business or discharge of official responsibilities will equally apply to governors. Ellipsis. Para 113. If the inner voice of the if the inner voice of the founding fathers may be any guide, it is proved beyond reasonable doubt that the President and a fortiori the Governor enjoys nothing more and nothing less than the status of a constitutional head in a cabinet time government, a few exceptions and marginal reservations apart. Ellipsis. Para 139. Emphasis. Of course, there is some qualitative difference between the position of the President and the Governor. The former, under Article 74, has no discretionary powers. The latter, too, has none, save in the tiny strips covered by Articles 163, Clause 2, 371A, Clause 1, Subclause B and Subclause D, Article 371A, Clause 2, Subclause B and Subclause F of 6th Schedule, Para 9, Clause 2 and 6th Schedule, Para 18, Clause 3 until omitted recently with effect from January 21, 1972. These discretionary powers exist only where expressly spelt out, and even these are not left to the sweet will of the governor, but are remotely controlled by the Union Ministry, which is answerable to the Parliament for those actions. Again, a minimal area centering around reports to be dispatched under Article 356 may not, in the nature of things, be amenable to ministerial advice. End of emphasis. The practice of sending periodical reports to the Union government is a pre-constitutional one, and it is doubtful if a governor could or should report behind the back of his ministers. For a centrally appointed constitutional functionary to keep a dossier on his ministers or to report against them or to take up public stances critical of government policy settled by the cabinet or to interfere in the administration directly, these are unconstitutional, fox pass and run counter to parliamentary system. In all his constitutional functions, it is the ministers who act only in the narrow area specifically marked out for discretionary exercise by the Constitution. He is untrammeled by the state ministers' acts and advice. Of course, a limited freewheeling is available regarding choice of chief minister and dismissal of the ministry as in the English practice adapted to Indian conditions. Ellipsis, para 154, emphasis. We declare the law of this branch of our constitution to be that the president and governor, custodians of all executive and other powers under various articles, shall, by virtue of these provisions, exercise their formal constitutional powers only upon and in accordance with the advice of their ministers, save in a few well known exceptional situations. End of emphasis. Without being dogmatic or exhaustive, these situations relate to item A, the chief choice of Prime Minister or Chief Minister, restricted though this choice is by the paramount consideration that he should command a majority in the House. Item B, the dismissal of a government which has lost its majority in the House but refuses to quit office. Item C, the dissolution of the House where an appeal to the country is necessitous. Although in this area the head of state should avoid getting involved in politics and must be advised by his Prime Minister or Chief Minister, who will eventually take the responsibility for the step. We do not examine in detail the constitutional proprieties in these predicaments, except to utter the caution that even here the action must be compelled by the peril to democracy, and the appeal to the House or to the country must become blatantly obligatory. We have no doubt that T. Smith's statement in Constitutional and Administrative Law by S.A. D. Smith, Penguin Books on Foundations of Law regarding royal assent holds good for the President and Governor in India. Quote, emphasis. A refusal of the royal assent on the ground that the monarch strongly disapproved of a bill or that it was intensely controversial would nevertheless be unconstitutional. The only circumstances in which the withholding of the royal assent might be justifiable would be if the government itself were to advise such a course, a highly improbable contingency, or possibly if it was notorious that a bill had been passed in disregard to mandatory procedural requirements. But since the government in the latter situation would be of the opinion that the deviation would not affect the validity of the measure once it had been assented to, prudence would suggest the giving of assent. End of emphasis. End of quote. Emphasis applied. Paragraph 297. Interestingly, as can be seen from the paragraphs reproduced above, while describing the limited nature of the scope of exercise of discretion by the President and the Governor, Krishna Iyer, Justice, referred to an except on how refusal of royal assent to a bill passed by the Parliament could only be done on the advice of the ministers and not on the personal discretion of the monarch, regardless of how controversial the monarch found the bill to be. He further observed that the discretionary powers of the governor existed only where they were expressly spelled out in the constitution, and even the exercise of such discretion was remote controlled by the Union Ministry. Para 298. Referring to the decision in Samsher Singh, quoted Supra, Krishna Iyer, Justice, in Maruram versus Union of India, reported in 1981, 1 SCC 107, again reiterated the position of the President and the Governor as figureheads in the constitutional scheme. However, he observed that they acted in accordance with the aid and advice of the Council of Ministers, save in a narrow area of power, and that the Governor vis-a-vis his cabinet is no higher than the President, save in a narrow area which does not include Article 161, thereby implying that there is a small area of discretion available with the governor, which however does not include Article 161. The relevant observations are reproduced herein below. Quote, Article 61, para 61 with ellipsis. It is fundamental to the Westminster system that the cabinet rules and the Queen reigns being too deeply rooted as foundational to our system, no serious encounter was met from the learned Solicitor General, whose sure grasp of fundamentals did not permit him to controvert the proposition that, emphasis, the President and the Governor, be they ever so high in textual terminology, are but functional euphemisms promptly acting on and only on the advice of the Council of Ministers, save in a narrow area of power. The subject is now beyond controversy, this court having authoritatively laid down the law in Shamsher Singh case. End of emphasis. Shamsher Singh versus State of Punjab in 1974, second volume, SCC 831. 1974, SCC L&S 550, 1975, first volume, SCR 814. So we agree even without reference to Article 367, Clause 1 and Sections 3, Clause 8, Subclause B and 3, Clause 60, Subclause B of the General Clauses Act 1897 that in the matter of exercise of the powers under Articles 72 and 161, the two highest dignitaries in our constitutional scheme act and must act not on their own judgment but in accordance with the aid and advice of the ministers. Article 74, after the 42nd Amendment, silences speculation and obligates compliance. The emphasis: the governor vis-a-vis his cabinet is no higher than the president, save in a narrow area which does not include Article 161. End of emphasis. The constitutional conclusion is that the governor is but a shorthand expression for the state government and the president is an abbreviation for the central government. End of quote. Emphasis supplied. Para 299. A constitutional bench, sorry, a constitution bench of this court, while dealing with the issue of discretionary powers of the governor in MP Special Police Quoted Supra and explaining the import of Article 163, Clause 2 of the Constitution, observed that even if discretion was not expressly granted upon the governor by a specific provision of the Constitution, it was open to him to act in his discretion in certain exceptional situations where, by reason of threat to democratic principles, he could not act on the advice of the Council of Ministers. The relevant observations are reproduced herein below. Quote, Para 8. The question for consideration is emphasis whether a governor can act in his discretion and against the aid and advice of the Council of Ministers in a matter of grant of sanction for prosecution of ministers for offences under the Prevention of Corruption Act and or under the Penal Code 1860. End of emphasis. Ellipsis. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of the Council of Ministers, but there can be cases where the governor is, by or under the Constitution, required to exercise his function or any of them in his discretion. The Constitution of India expressly provides for the contingencies cases where the governor is to act in his discretion. Articles 239, Clause 2, 371A, Clause 1, Subclause B, 371A, Subclause 2, Clause 2, Subclause B, 371A, Clause 2, Subclause F, and Paras 9, Clause 2, and 18, Clause 3 of the 6th schedule are some of the provisions. Emphasis. However, merely because the Constitution of India expressly provides in some cases for the governor to act in his discretion, can it be inferred that the governor can so act only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of a matter where the Constitution expressly provides that the governor is to act in his discretion. Article 163, Clause 2, therefore postulates that there can be matters where the governor can act in his discretion even though the Constitution has not expressly so provided. End of emphasis. Para 12, ellipsis of part of it. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of the Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out herein above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. Emphasis. It is also recognized that the concept of the governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled, which from its nature is not amenable to ministerial advice. End of emphasis. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. Ellipsis. Para 19. Article 163 has been extracted above. Emphasis. Undoubtedly, in a matter of grant of sanction to prosecute, the governor is normally required to act on aid and advice of the Council of Ministers and not in his discretion. However, an exception may arise while considering grant of sanction to prosecute a chief minister or a minister, whereas a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the Council of Ministers disables itself or disentitles itself. Ellipsis. Para 32. If on these facts and circumstances the governor cannot act in his own discretion, there would be a complete breakdown of the rule of law, inasmuch as it would then be open for governments to refuse sanction in spite of overwhelming material showing that a prima facie case is made out. If, in cases where a prima facie case is clearly made out, sanction to prosecute high functionaries is refused or withheld, democracy itself will be at stake. It would then lead to a situation where people in power may break the law with impunity, safe in the knowledge that they will not be prosecuted as the requisite sanction will not be granted. End of quote. Emphasis applied. Para 300. The decision in this case was a step forward from the general rule laid down by the larger bench in Samsher Singh quoted supra. However, what is essential to note is that the court did not dilute the general rule laid down earlier and only allowed for a very limited scope of discretion for the governor in certain exceptional situations in light of Article 163, Clause 2. The extraordinary nature of the exceptional situations envisaged by the court can be gauged from the use of the expressions peril to democracy or democratic principles, bias is inherent and or manifest in the advice of the Council of Ministers, Council of Ministers disables itself or disentitles itself, and there would be a complete breakdown of the rule of law. End of emphasis. End of quotes. Whenever the situation arises for the governor to exercise discretion in discharge of a function which is ordinarily to be exercised upon the aid and advice of the Council of Ministers, it is these exceptional circumstances that the governor must take into account before rejecting the aid and advice tendered to him. Courts too, when judicially reviewing the exercise of discretion by the governor in such cases, must be guided by the situations as described in the decision in MP Special Police quoted supra. Article 200 being a provision where the governor must act on ministerial advice as a general rule, the aforesaid exposition would squarely apply to this provision as well, thereby severely curtailing any possibility of exercise of discretion by the governor. Para 301. Another constitutional bench of this court in Nabam Rebia quoted supra had the occasion to discuss at length the nature of the position of the governor in the constitutional scheme along with the source and scope of his discretionary powers. The court held that the discretionary powers of the governor could be traced back to Article 163, Clause 1, that is, he could act in exercise of his discretionary powers only where expressly provided for under the Constitution, or where the interpretation of a constitutional provision could not be construed otherwise, or in cases where this court has declared the exercise of powers to be done by the governor in his discretion notwithstanding ministerial advice. Further, the court held that the finality expressed under Article 163, Clause 2 was only in respect of those situations where the exercise of discretion by the governor was permissible under the framework of Article 163, Clause 1, and any exercise of discretion beyond the jurisdiction provided by the Constitution would be subject to judicial review. The relevant observations are reproduced herein below. Quote, para 167 point, para 147.1, ellipsis of first part, or ellipsis of part of the para. Article 163 further warrants that the governor would exercise his functions on the aid and advice of the Council of Ministers with the Chief Minister as the head. The above edict is not applicable in situations where the governor is expressly required to exercise his functions The question that will need determination at our hands is whether the underlying cardinal principle, with reference to the discretionary power of the governor, is to be traced from Article 163, Clause 1 or from Article 163, Clause 2. Ellipsis. All in all, it is apparent that the governor is not assigned any significant role in the executive functioning of the state. Para 147.2, ellipsis of part of it. Insofar as the legislative process is concerned, the only function vested with the governor is expressed through Article 200, which inter alia provides that a bill passed by the state legislature is to be presented to the governor for his assent, and its ancillary provision, namely Article 201, wherein a bill passed by the state legislature and presented to the governor may be reserved by the governor for consideration by the president. Ellipsis. All in all, it is apparent that the governor is not assigned any significant role even in the legislative functioning of the state. Para 148. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions as would assign to him a nominating position over the state executive and the state legislature. The interpretation placed on Article 163, Clause 2, on behalf of the respondents has just that effect because of the following contentions advanced on behalf of the respondents. Firstly, whenever a question arises whether in discharging a particular function the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision itself postulates that, quote, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, end of quote, according to the respondents, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above position will convert the governor into an all-pervading super-constitutional authority. End of emphasis. This position is not acceptable because an examination of the executive and legislative functions of the governor from the surrounding provisions of the Constitution clearly brings out that the governor has not been assigned any significant role either in the executive or the legislative functioning of the state. The position adopted on behalf of the appellants, on the other hand, augurs well in an overall harmonious construction of the provisions of the Constitution. Even on a cursory examination of the relevant provisions of the Constitution, we are inclined to accept the contention advanced on behalf. Oh, sorry.